for today in this role. Do you? Okay. Have they discussed this with you? They being Mr. Harvey, Mr. Garner, or Miss Westmoreland? Okay. And you're okay with Mr. Botts representing you today for the purposes of this particular hearing? All right. All right. Mr. Ryan and Misty Williams. Good morning, madam. All right. Mr. Smith, Mr. Uhowski, Ms. Knight, Ms. Hilton, Mr. Atkins, and Mr. Brown. Good morning. Good morning. All right. Is Mr. Yusuf over there in the corner? Okay, all right.
Court either read through the transcript, it's a number of pages, or listen to, look at and listen to Mr. Copeland's audio visual interview on it. But my objection to that is that it contains, they're playing the video, and essentially the testimony is coming out based on this audio visual interview, as opposed to him testifying about it and either admitting or denying that this is what he knows. So my objection would be foundation, first and foremost, and then the other things that I've indicated, hearsay, our inability to confront the witnesses that he says he gets this information from, who would be, I think they're going to say these are co-conspirator statements, right? Denikin Garlington, for example, he's a co-defendant. We can't call him and cross-examine. And then finally, that some of his testimony, some of his statements here is speculation. So that's my objection.
Okay. All right. Ms. Hilton?
Yes, Your Honor. So first, I want to start with the foundational part. We have not asked Mr. Copeland about the night Donovan Thomas was killed. We did, in fact, ask Mr. Copeland about that. Your Honor, when I had
Ask him about the guns or who was in the car?
We did. So, Your Honor, on June 13th, we actually asked this series of questions. And this is all in relation to the night that Nutt was killed. My question to him was, after you left Mechanicsville, did you go anywhere?
Okay.
After leaving Mechanicsville, from what you remember? Yeah. Do you remember where you went? Pick little D up. Okay. And which little D are we talking about? The one that always be with me. Okay. Is that the little D you referenced as your son? Yeah. Do you remember where you picked little D up? Where did you pick him up at? McDonald's. Where was the McDonald's? On Cleveland Avenue. And when you got to McDonald's on Cleveland Avenue, was there anyone else with little D? Just him and Shannon. Anybody else? Just him and Shannon. When you picked up little D, what did Shannon do? What do you mean? You said you picked little D up. Did you also pick up Shannon? I said I picked them both up. When you picked up both of them, where did you all go? I blanked out after that. You blanked out after that. Okay, why did you blank out? Because they were saying that I got the phone call. Do you remember who called you? So I asked him what occurred in the car. What's happening? He says he blanked out. So at this point, if he blanked out, he does not remember anything that happened in the car, which would be the conversations that he had with little D. And well, what he's now saying Shannon, but previously he told the detective that Nard was in the car with him. And I believe that I asked him further on, and we don't have this part of the transcript, did Nard ever get in the car with you? And he says, no. So, Your Honor, we have confronted him as it relates to what occurred. Let me go further. Excuse me. I'm going to go down to the transcript. Now, before Monson called you, did you, Shannon, Little D have any conversation about Nutt being killed? No. was his response. That's a complete contradiction to, that's impeachment by inconsistent statement that he said, no, they did not have any conversation about Nut being killed. So as far as foundation is concerned, we have met.
So you want to know where to invest $1,000 right now? Well, forget about stocks, crypto, and real estate, because there's a little known trend taking the world by storm as we speak called e-farming. E-farming creates online assets that have the potential to generate passive income that grows over time, much like traditional real estate. It's one of the most exciting new side hustles that doesn't involve getting involved in physical products or sacrificing tons of free time. Stick around for 60 seconds and I'll show you.
We have met the burden of the fact that this statement now comes in, one, impeachment by contradiction, but two, as a prior inconsistent statement. As far as hearsay, Your Honor, you've already ruled that what Demekian told Copeland in the car comes in as co-conspirator hearsay. The court has already made a ruling on that. And when you look at page 488, excuse me, starting at line 1, Detective Thorpe's question is, okay, so let's go back to Nut. Make sure I got everything right. Demekian pretty much told you it was him, Shannon, Nard, Bentley. Copeland corrects him. Nah. It was Demekian and Thug, D and Thug and the girl. Supposedly went to Bentley's house. This is based upon what Demekian told him. He says, you feel me? And when they got finished doing that, they supposed to pull up on him at the house. But I think the girl Bushi, you know what I mean? That's the girl who's supposed to, she know what's going on. You know what I mean? This is the girl Shannon turned against me. You remember they came and shot at us while I was in the car? This is the girl who I thought told them that I was at the hotel with them. He's now referencing the detectives about, I believe in the January 28th interview. He's now referencing what he told the detectives in January 28th about Bushi potentially setting up him getting shot at on the highway. And then detective says, right? Then Thorpe says, So it was Yak driving, Shannon with the AK, Nar with the pistol, and Doo-Wop with the pistol? He says, nah, I don't think Doo-Wop had no pistol. Okay, right. But you just know what seats, how everybody was sitting in the car. All you know is Yak was driving. Yeah, I just know Yak. They say Yak was the driver. Again, talking about with Demekian. Because he said, if that's based on what Demekian told you, yeah. Little D, okay. Did they say that anybody else or just in y'all circle? He says, nah, I told people, you did? Because I just wanted somebody to believe that I ain't do it. Yeah, I told who did it. Like, shit, boy, goddamn, they did. You know what I mean? I never know what was going to happen. I was just like, don't say nothing. Him telling what he told Big Blue. Then continue on. But I think if y'all, and it's indiscernible, but I think he's saying that Shannon told New Baby. I know Shannon too much. I think Shannon told New Baby himself. You feel me? And New Baby's his girl? Yeah, New Baby. So you know what I mean? Because the story came out, though. 2 people said it. What? That Shannon and them killed him. You feel me? Like Bentley's girlfriend is Nut's sister. Yes, his baby mom is Nut's sister. And you know what? You know what she told him? What? How could you be around him and he's supposed to kill my brother? And Bentley said, if you feel like he killed your brother, just let me know. One call and it's on. That's why me and Bentley fell out. You know what I mean? So again, he's offering that comment to say this is why him and Bentley fell out. Then he says, you know what I mean? Like, you don't let nobody tell you no shit like that. Nigga, you know I ain't had nothing to do with that nigga getting killed. Detective Thorpe says, I'm gonna make a phone call. Detective Thorpe actually leaves the room. And then Kenneth Copeland continues to say, you feel me? So when I tell Bentley that, bro, you sitting around here telling this girl if she want me dead, just say it. And they going, you know what I mean? So I believe you when you're saying it. They would have killed me to get it off of him. And then he goes and say, I told Thug that. And Thug was like, nah, he's just trying to throw her off. You know what I mean? Hell no, I ain't going for it. So, Your Honor, the hearsay portion that defense counsel is claiming is hearsay is not. It is the co-conspirator statement of Demekion Garlington when he told Mr. Copeland what happened the night of the murder. And we have laid the foundation to introduce that because we've asked Mr. Court, what did you all talk, or did you all talk about the murder when the three of you got in the car? And he says no. So this is a complete contradiction to that first assertion. So foundationally, it gets to come in as impeachment by a prior inconsistent statement. It is not hearsay because the court has already ruled that what Demekion told Mr. Copeland is a co-conspirator statement. And that really ends on page 489. Line 14, anything that Demekion told Copeland is from page 488 when Detective Thorpe is trying to clarify what Copeland said Demekion told him. And that goes all the way to page 489, line 12.
What if your smile could go from looking like this to this? Would you be more confident? Would you laugh a little louder? Would you finally open your mouth and express how happy you really are in your family photos? Well, I'm proud to say that Nubia Dental Implant Center has restored thousands of smiles, and we know the value of being able to smile again. Full mouth permanent dental implants is your solution. And believe me, this isn't a one-size-fits-all kind of solution. We give our patients the opportunity to design the smile of their dreams. With us, you pick the shape and color of your new set of teeth. Then, with our technology, we digitally plan the procedure in advance so that your permanent set of teeth are delivered the day after your surgery. A new life is possible for you, and the first step is being able to smile again. So why wait? All you have to do is click the link below and take our 60-second quiz.
And Thorpe confirms multiple times, this is based upon what Demekion told you. And he says, yeah. So again, this is the co-conspirator hearsay. After line 14, that's when he begins
What page now?
on page 489, that goes into who Copeland told about it. So Copeland is now saying, I told Big Boo about it. And he told Big Boo not to say anything.
Is that going from 480, line 14, page 489 to the end, 491 at line 10?
No, that's only from page 489, line 14 through page 489, line 24.
Okay.
Then when you flip onto page 490, this is Copeland telling the detectives that he thinks Shannon told New Baby. And he's saying that more people knew about the murder, so his thought is that maybe Shannon told New Baby. Now, that is speculation. The state has no objection to taking out that portion of it.
What part?
So that would be page 490, line 1 through 8.
All right,
And I would have to get the timestamps for
Mr.
that.
Short, you,
I mean, Mr. Adams is gonna argue, I already did this, but.
but it's your client, so that's what I wanted to ask you.
In
Okay.
addition to the overall statute,
We,
specifically, I'm also arguing that 491 through H.
491 to what, sir?
490 lines 1 through 8, as Ms. Hilton just said. That-
Okay, all right, yeah, well, I think that she's agreed to redact that as it pertains to your client,
Yes, sir.
among any other objections that are being lodged, to include the general objection about not playing the videos at all. So,
And I'll actually extend that to line 12, Your Honor.
so 1 to 12
Yes.
on page 490.
Yes.
All right, that can be omitted out. Anybody wish to have any discussion in regards to that particular omission of just 490 to lines 1 through 12? All right, hearing none, those will be edited out. Okay, what
And
else do you have?
Then he picks up explaining that
He being who?
Mr. Copeland picks up stating that at line 15,
Of what page?
490, that his baby mama is Nut's sister, referring to OG Bentley. And he goes in to say, you know what she told him? How could you be around him? And he's supposed to kill my brother. And Bentley makes his comment, like, if you feel like he killed your brother, just let me know, one call and it's on. That's why.
Okay, let me just back up a second if I can interrupt you, sorry. When he being Mr. Copeland is talking about his baby's mama, who's that?
He's talking about
That
Nuts.
mother of it. Who's he referencing?
He's referencing Mr. Donovan Thompson's sister, who is also the mother of one of Kelvin Treadwell's children.
We heard testimony about that.
Yes.
Okay, all right,
And
okay.
it's not hearsay because he's given his reason why him and Bentley fell out. So he's saying, he being Copeland, excuse me, is saying that the sister in a conversation with her child's father is saying, how could you be around him? Meaning, how could you be around Copeland if Copeland's supposed to kill my brother? And then Bentley's response to that was, if you feel like he killed your brother, just let me know, one call and it's on. Copeland is saying that conversation is the reason why he and Bentley are no longer friends. And that furthermore, he says to Bentley, why would you let her say that to you if you know that's not true? You know, I have had nothing to do with him getting killed, him being Donovan getting killed. And he also tells Bentley, bruh, you sitting around here telling this girl she wants me dead, just say it. So, you know, I believe when y'all are saying they would have killed me to get it off of him. And then he being Copeland, tells Thug about the conversation of Bentley with his girlfriend. And Thug's response to that was, he's just trying to throw her off. Like, don't worry about that statement. And so we believe that all of that comes in as relevant, that is non-hearsay in this case. So
Chupa Chups Melody Pops. Taste the music.
the entirety of the section, exclusive of the part that we agree to redact, should be played, excuse me.
Okay. All right. Can you give me the time references,
Yes.
if you wouldn't mind?
So for the first portion, Your Honor, which is
Page 488 to 489, line 12.
yes, that will be approximately 5:33:55
2.
to 5:35, approximately 15.
Okay. And
This-
then the next portion, I believe, is um, 9:24.
Yes, Your Honor, and that would be, I would say approximately 5:35:20
5:35:20
to approximately 5:35:32.
Okay. All right. And then the omitted part that you wished you've agreed to take out in regards to Mr. Stillwell on page 490, lines 1 through 12. What is that?
I think, Your Honor, that's gonna be approximately 5:35, type 40 to 5:36:13.
Okay. All right. And then 490, line 15, I think through the end. What does that go to?
So from 490, line 15 through, and this actually bleeds into what we just discussed that we agreed
491,
to.
line 10 or something like that. I think that was the end of the section that you were talking about.
Yeah, so that bleeds into, so we would start around 5:36:21. And that would be 490, excuse me, 5:36:15, which would be 490, line 15. And that would go all the way through page 491, line 16, which would be 5:37:00.
Okay. All right. Mr. Adams, anything else before I rule?
Yeah, I want to address the foundation argument again, because Madam Prosecutor quoted from her direct examination of Mr. Copeland in asserting that they had laid the proper foundation to impeach him with the specifics of this statement. The last question that I heard after Mr. Copeland says, I blanked out, is where he's asked about whether in a phone call that he receives or in the car, and that's very specific, was there any discussion about Nutt's murder? Right?
That was on the stand.
Right, when he was on
the stand earlier.
Right.
Okay.
That's as far as the questioning goes in terms of any details. Right. Now, if you look at the transcript and if you listen to his statement, there's no indication as to the information that he's relaying that he got from Demikian or anyone else when he got that information. So I would agree, right? I'm going to be as objective as I can here and say that if the state had gone further in their questioning, right, and say, okay, well, what about later on? Was there did you all meet anywhere? Did you all talk about this at any point after that? But they were very specific, and they ended the last question about what he knew about Nutt's murder was in a phone call or in the car. And so it is clear in my reading from the transcript that Mr. Copeland is referencing other conversations that take place at other times, and they can't simply say that, well, this is impeachment by contradiction based on the answer to those two questions. And so I think that there's additional foundation that needs to be laid before they can simply carte blanche just kind of throw this entire statement in there. Additionally, that's foundation argument. In regards to page 490, starting at line 15.
Yes, his baby's mom is not sister.
There you go. The entire conversation is what Nutt's sister, who is not a co-defendant, what her conversation is with Bentley, who is not a co-defendant. And to say that the reason we want that here, that is clearly hearsay. Copeland's relaying what he knows about a conversation between two other people, not even him. He's not party to that conversation, right? He hears about that conversation. So he's relaying what he heard there and the statements that are made by Nutt's sister and Bentley. And so it's clear that that's hearsay.
Here,
Can
I stop you? I have
Yes.
just a question about that. Would that be that section where Mr. Copeland's talking about his baby's mom is Nutt's sister and that, would that go to effect on listener about what he did or what he said afterwards?
I don't think so.
Why not?
I'm
I'm asking because I follow your argument about, and I'm looking at the transcript as well, and about what is being said, but why wouldn't that fall under that issue effect on listener where he's clearly talking about what the mother, the baby's mama, Nutt's sister, and what she told him, and then
and Bentley.
and Bentley.
Because, and here's why, because the state points to one line on line 21 where it says, that's why me and Bentley fell out. Well, there's no relevance to that. That doesn't have anything to do with his recitation of the information he has about Nutt's murder, right? Because those are the questions that are being asked, and he's relaying what he knows about Nutt's murder. And so for him to inject in there this conversation between Nutt's sister and Bentley, and what they said, and that's why he and Bentley fell out, because Bentley makes a statement about that conversation that doesn't really have anything to do with the information that's being relayed.
Okay, let me freeze. I'm gonna let you finish your argument, Mr. Adams. I want to ask the state's response as to what's the state's response as to that, basically 490 lines 15 through 22.
Yes, Your Honor.
What, because it is a hearsay statement from Copeland's relaying what Nutt's sister and Bentley told him.
So let's put it in further context. Bentley, the state alleges, is a co-conspirator in the YSL gang conspiracy.
He's an unindicted co-conspirator.
He's an unindicted co-conspirator. And Mr. Copeland has just reiterated Bentley's role in the murder of Donovan Thomas, that he is the place where both the car gets disposed of as well as the guns get disposed of. And so what he is saying to the police is, Bentley and I have now fallen out. Bentley and I are no longer friends, given what he is telling this woman about wanting to kill me when he knows I had nothing to do with this murder. And so we're not offering it for the truth of the matter asserted as to whether or not Bentley actually said, if you feel like he killed your brother, just let me know. One call that it's on. It is the effect that had on Mr. Copeland, and in turn, what he does with the information. He then confronts Bentley about it, but then he also asks Thug about it as well. And that is why, to put what he did with Thug into context, that the jury needs to understand what preceded that. Not that we're offering it for the truth of the matter asserted, but what preceded. Excuse me. But what preceded why he was upset that Mr. Bentley would even mention that to Mr. Donovan Thompson's sister, and the fact that it upset him so much that he even mentioned it to Thug. Like, why would this co-conspirator say that, and he knows I have nothing to do with this murder? Why would he tell her that he would have me killed, and he knows I have nothing to do with this murder? And so again, it's not being offered for the truth of the matter asserted, but it's being offered for the effect on the listener, being Mr. Copeland and what he did with that information. And I can't address the foundation issue again, Your Honor, regarding us getting this into evidence. So first things first, Mr. Copeland told the detectives that Little D told him about the murder once he got into the car. He began speaking about the murder once he got into the car. And then in his initial statement, he says that once Nard got into the car, they stopped talking. And then when Nard got out of the car, when they get to Sky House, they continued the conversation. So when I asked him in direct, was both, did you, Shannon and Lil D, have any conversation about Nut being killed? And this is why they're in the car. He said, no. He said, I did not, which is inconsistent and in contradiction to what he told police. What he told police is, in the car, he told me about the murder. He told me about what happened. And so it is, the foundation has been laid for this to be entered.
All right, Mr. Adams, you can complete your argument. I thank you for allowing me to hijack you at that point.
No, I think I've done. I'm recounting what I recall from his direct testimony. I still don't think that there's been specific enough questions asked of him on direct such that what would be played in this would be impeachment by contradiction. And also, I've got to say, I reject the thought, going back a little bit to the other argument, that, Bentley's an unindicted, everyone's an unindicted co-conspirator. They hear the state tell it. If their name is referenced, they have some conversation about it. If they were around when something happened, they're an unindicted co-conspirator, and so their statements automatically come in. And I reject that. If they believe that Bentley was involved in the commission of Nutt's murder, they could have indicted him and charged him just as a co-defendant, as opposed to what they're arguing now as an unindicted co-conspirator. So I'm going to rest on all the arguments I made previously and ask you that these items be kept out. Be redacted.
Okay. All right, the court's had an opportunity to consider both arguments of counsels for the defense and for the state in regards to lines 488 line 1 to 491 line 10 and the corresponding video and audio marks that have been stated for the record already. In this particular period, talks or references where Mr. Copeland reportedly talks about Nutt's murder based upon what he heard and what he thinks and what he finds from the defense's perspective, and their basis for their exclusion are hearsay, confrontation, speculation, lacks foundation. The state has responded by saying that they have in fact laid the foundation. They've also indicated that for a period of this where you have conversations in regards to what Mr. Garlington told Mr. Copeland, that those would be admissible under co-conspirator statements, which the court's ruled upon already. The other basis is prior and inconsistent statements. The court is of the opinion that based upon what the court has heard from direct testimony, that in his direct, he says in pertinent summation that he doesn't remember what happened in the car, or he went blank, or words to that effect. Without having a transcript, I can't say the exact words, but the court is of the opinion that the state has asked a predicate foundation to explore from Mr. Copeland impeachment, at least impeachment by contradiction or prior inconsistent statement. So I'm going to omit those, allow state to play that portion of the tape over a defense objection. Mr. Adams, I will give you and others a continuing objection.
Thank you.
And that does not include the omission of page 490, line 1 through 12. That's Mr. Stillwell's statement, which are going to be omitted by agreement by the state and Mr. Sharp. All right. Okay.
Yes, sir.
All right, let's move on to the next one, please.
The next one is, we jump down to, is going to be page 499, line 14 through page 500, line 6. In those excerpts, if the court will take a look at it, the detective essentially, it's mostly the detective speaking. Mr. Copeland has a few lines in there as well, but it's mostly the detective speaking. And the detective is giving what I would define, what I would call a speech about how they want Mr. Williams, how Mr. Williams is using others for his, quote, their words, reign of power, and how Mr. Williams eliminates people. Or his enemies. His enemies is my verbiage. People is what the detective says. So if we look at line 14.
On page 499.
499, sir.
Okay.
The detective Dennis is talking. He says, you want to know what we want? We want this stuff to stop. If y'all were just making music, I like rap music. I like some of Thug's music. I think it actually says every now and then. The transcript says if he has any. Mr. Copeland just replies, yeah. Detective Dennis goes on and says, but that ain't what's going on. That's a fake card for indiscernible, all this other stuff. That's the detective talking, giving his opinion. Mr. Copeland responds, it didn't start until we got Thug. And then Detective Dennis responds, exactly. He basically used y'all as his gunners to help him get this reign of power. Nut, get out the way. You're a threat. Anybody that's a threat, he eliminates them. So at what point do y'all figure out that y'all can be eliminated too? He don't care about nobody but himself. What it sounds. Ms. Copeland says, oh, well, that's what it is. Detective Dennis says, so why would you stick around and let this man bring to your demise? So I'm going to go back to some things I say often. Sounds to me like, it seems to me that this is an easy one, right? The state is going to disagree. But this is Detective Dennis, none of this is relevant. The detective's thinking about, what Mr. Williams's music means or what type of person, what his character is absolutely not relevant. There's nothing that this adds to the case. There's nothing that this adds to any. It's not an item of evidence. It's just the detective's opinion. Wherever he gets his opinion from, whatever he forms that opinion based upon, that's him. But it's not relevant. His opinion is not relevant. It touches upon Mr. Williams's character. It defines Mr. Williams' character in a way that is impermissible. And again, it's not based on any fact or evidence. It's based upon his opinion. And it's a commentary upon Mr. Williams's music and what it means, which again is the detective's opinion that has no relevance whatsoever for the jury's consideration. And so just based upon that, and of course doesn't give any foundation. I guess I'll throw that word in there, foundation for where the detective is getting this opinion other than just that's what he thinks. His opinion is more prejudicial than probative. I would say it's not probative at all. And so I'd ask that it be redacted.
Hi, Ms. Hilton.
Of course not.
Aye.
Your Honor. Your Honor, the state will agree that beginning at line 23
On what page, ma'am?
of page 499 to page 6 of 500.
You mean page 6 of 500 or?
Page 500, line 6, I'm sorry. So page 499, beginning at line 23, where it says Detective Dennis, exactly, he basically used y'all as his gunners. Through page 500, line 6.
Okay, tell me why you think that I should,
The state has no objection to that portion being redacted.
the line 22 of page 499,
So line 23
line 23
of page,
of page 499, so.
yes, through line 6 of page 500.
To page 500, line 6.
The state has no objection to redacting that portion.
Okay, let's talk about the I guess the rest, the from line
14 through 22.
Yes, yes, ma'am.
Your Honor, in line 14 through 22, detective, well, let's go a few lines before this. Prior to this particular statement that Mr. Investigator Dennis says, they're still talking about Copeland's kind of concern still about being labeled a snitch. And who, he's in this space of, what do I do? If I tell, then the streets aren't going to like me. If I don't tell, this could happen to me. And what Detective Dennis says to him is, we want this stuff to stop. If y'all were just making music, he says, I like rap music. I like some of Thug's music every now and then. Yeah, but that ain't what's going on. That's a fake card, all this other stuff. And then Copeland says, it didn't start until we got with Thug. This line is in direct contradiction to the defense's assertion in opening that the focus of their investigation was all about Young Thug and his music, that we attacked as the state, as the police officers, that we were only focused on using these lyrics and this music, and then we created a case solely based off of the music. And this is in direct contradiction to that. In the course of the investigation, the investigator Dennis, is telling Mr. Copeland, this is not even about the music. Matter of fact, I like some of his music. This is about what has been happening in these streets, what the shootings that have been going back and forth for now, at this point, 6 months, and putting it into that and encouraging Copeland to continue to tell the truth about what has happened. And then Copeland's response to that is, this didn't start until we got with Thug, until he, I believe when the we is him, Demekian and Shannon, that all of this violent stuff started happening. And it's not just about the music. And so we believe that this is in direct contradiction to the assertion that the police officers were solely focused on music and lyrics in this case, but no, they were focused on stopping crime, and it had nothing to do with the music. So for those reasons, Your Honor, we believe that that portion is relevant.
Mr. Adams?
So the only thing that's, two things. Number one, I think we all know that what is said in opening
Not
and
evidence.
not evidence, questions by the attorneys aimed at getting at a certain point, not evidence. And so what they have to prove in court, they have to prove by way of evidence. What the detective says in this excerpt, and we're talking strictly about line 14 through line 22, this is the detective's opinion on what the music is or is not. So for example, if you look at line 19, when he says, but that ain't what's going on, that's a fake card for all this other stuff. Well, if that's the case, then let's prove it with evidence as opposed to giving the jury the detective's opinion as to what that is. Because without more, what the jury ends up getting is the detective's soliloquy on what he thinks the music means, whether or not it's being propagated for art, or whether or not it has something indeed to do with the rest of the case or any of the criminal activities that have been indicted. And they've got to prove that with evidence. I just don't think that there's anything here. I don't think number one, his opinion is not relevant in regards to this item of evidence. And I think there's a fair amount of speculation on the state's part. I've said it before. I understand they have their theory, but when Madam Prosecutor says that Mr. Copeland's response, it didn't, on line 22, it didn't start until we got Thug. When she opines, well, when he says we, he means Shannon and Demekian, and this is who he means. Well, there's no, they don't know that. They don't know that any more than we do, unless Mr. Copeland gets on the stand and says, hey, this is what I meant, and this is who I'm talking about. That hasn't happened yet. So that part is just speculation. But overall, these few lines that we're talking about is nothing other than the detective's speculation as to what he thinks the music is in his opinion, and that's not relevant and should not be allowed. Yes, one more.
May I add something?
Sure.
Also regarding this, the state is making the argument that this out of court statement should be played because of arguments that some defense counsel made during opening statements. My recollection is that certainly that Investigator Dennis has been on the stand and he provided live testimony rebutting the defense argument about following lyrics and instead said, no, we follow crime and then found lyrics. I believe that was Dennis. It may have been Gaither. Anyways, the state has provided live testimony regarding that issue and their counter to whatever was argued in opening that they say was argued in opening. So I don't know why we would.
What would you do to protect the ones you love? MAD is leading the charge to end impaired driving. With anti-drunk driving technology, prevention, support for victims, and stricter laws, we're more determined than ever.
I will fight till the day I die to make sure that this doesn't happen to anybody else.
Think before you drink. It changes lives.
We're up for the challenge. Are you? Impaired driving ends here. Join the movement at mad.org.
Knowing that this has been argued through live testimony, I don't know why we would allow out-of-court statements, hearsay statements that also have problematic parts in speculation, as Mr. Adams has stated. I don't know why we would allow that into evidence when the state has already been allowed through live testimony to address this issue.
Okay.
And if I may just add very briefly, I also think that this is probably not necessary because, as I stated before, with setting opening and the questions of the attorneys are not evidence.
But the other thing I was going to mention, Mr. Sharp just reminded me, the court is very aware that you are not required to present any evidence at this point in time. You have not elected that decision, and that's of no consequence to me what they're saying you've said. You said. So I'm not taking that from that vein at all.
Also true. And I do think it is, and I know it's been a long time. We did opening back in November or whenever it was.
Yeah, it was November, I
Right.
think, yeah.
But I think the state isn't remembering correctly what Mr. Steele said in opening. I do recall that he made reference to the state cherry picking lyrics and so forth, but again, so I think their recollection of that is incorrect, but I don't think that's part of the calculus or the consideration at all because it's not evidence.
Right.
You're right, so I have just problem about those last two.
Sure.
So first, as it relates to the fact that the state cannot rebut what is said in opening, and looking at 24-6-621,
24-6.
which is impeachment by contradiction. Also in reading Carlson's on page 351, which is citing to federal law. Federal courts allow parties to counter misrepresentations and in an opponent's opening statement with contradictory proof.
What page is that? I'm sorry.
Page 351.
What part of that?
If you go to,
I see it. I see about the fourth paragraph down.
yes, Sam.
Okay.
And rebuttal will sometimes mean the countering of factual assertions made during defense counsel's opening statement or for them cross-examination of the government witnesses. So the state can bring in evidence to rebut what was said in an opening statement. But furthermore, Your Honor, this statement, what investigator Dennis said about the music is an adoptive admission by Mr. Copeland. Mr. Copeland does not disavow that this is just about making music. He, matter of fact, agrees with Detective Dennis. And in court, if you can recall, Your Honor, Mr. Copeland made it seem that YSL is just a music group. Matter of fact, I think he even said the only gang that he associates himself is 372, that he's not even a part of YSL. When I asked him directly, are you a part of YSL, the gang? And he disavowed that. So when you look at what he's testified into court about his disavowal of YSL, that YSL is just a music group, that this is in direct contradiction to that assertion. And he adopts what Detective Dennis says by not disavowing it, not saying, no, it's only about the music. He says, yeah. And matter of fact, he further says, it didn't start until we got with Thug. So, Your Honor, for those additional reasons, we believe that this portion, page 499.
We got with Thug or we got Thug? That's what this transcript says we got Thug.
I think when you listen to the recording, it says until we got with Thug.
Let me listen to that portion, please. I just want to listen from about line 14 to line 22. Okay.
Yes,
Mr. Sharp, you have something else?
Well, it just occurs to me that this adoptive admission argument.
Don't worry about that.
Not only are
Don't worry about that.
Okay.
Okay, don't worry about that. I mean, I'll let you complete your argument if you want, but I'm not convinced it's an adoptive admission, okay?
If you're not convinced,
All right.
good.
Okay, all right.
Let me attempt to convince the court also by just looking at 24-6-6-21. What it actually says is a witness.
Yeah, that's why I'm not convinced, okay? All right. Okay.
Hey, I'm just gonna start at page, excuse me, at time stamp 544-34.
5:44:33 to about what time?
To about 5:44:50.
Okay. Hold on.
And then like one took them keep coming back telling them, I've been talking to the police, I've been talking to the police. And they just feel as in there ain't nobody locked up, ain't nobody got no warrants. So I wouldn't take that because this is the truth is everybody say, I can't be telling that because whatever I know, they get locked up. You know what I'm saying? Right. So they know that. And they ain't get locked up, so they know, well, I ain't tell you. That's the only thing they keep me out of it.
But what happens when they start getting locked up?
So what I'm saying, that's why they
Started much earlier. I'm going to restart at 5:44:20.
I know.
You want to know, we want the stuff to stop. If y'all was just making music, I like rap music. I like some thug music every now and then.
Yeah.
But that ain't what's going on. That's a fake card for fueling all this other stuff.
It didn't start till we got stuff.
Exactly.
Yeah.
One more time, please. Christina? Anybody else who wants to listen to it, you're welcome to come up and listen as well. What?
Ready on?
Not yet. Not yet. I'm almost ready.
Fish. That's not to insult you. That's being real. Like,
I know. I do.
you want to know, we want the stuff to stop. If y'all was just making music, I I like rap music. I like some thug music every now and then.
Yeah.
But that ain't what's going on. That's a fake card for fueling all this other stuff.
It didn't start till we got to it.
Exactly.
Yeah.
Okay. Detective Dennis on lines 14 through 16, part of it is, I like some of Thug's music now and then, or to that effect. It's not if he has any. And then on line 22 of 499, it does say it didn't start till we got with Thug.
But what does that mean?
I don't know. I'm just listening to it. Okay, so Jenny, you want to listen to it as well? I mean, I'll give you the opportunity to do so.
I don't disagree that what's in the transcript is
It's not quite accurate. It's close in regards to that particular portion of what Detective Den starts off with. Okay. All right. Based upon the court's listening to this particular portion of lines 14 through 22, the court is of the opinion that it is opinion by Detective Dennis and it is speculation. So I'm going to exclude it at this time and omit it. Just that particular section.
Thank you, Your Honor.
All right.
Can you give me the timestamps starting at line 14 or middle line 16?
So it should be 544. I have 34.
You said it was 29 earlier.
Well, I started at 23, so I'm going to say 544, 29 approximately to 545,
28.
23.
544, 29 to 545, 23.
Yes.
Okay. Any further argument or discussion in regards to that portion? Okay. All right.
Next one, on the last page, that's the report.
Hang tight 1 second. All right, sir, I'm with you.
Yes, sir.
Is it 523?
Yes, 510, line 4 to page 511, line 3.
Okay, 510, page, line 4.
Yes, sir, to page 511, line 3.
Okay.
There's a conversation between the detective and Mr. Copeland. Essentially what they're doing is they're talking about who to go after first. And there's some opinion as to who they should go after first. Opinion about Shannon, opinion about D, and opinion about Doo-Wop. In relevant part, I'm going to just kind of read through from line 4. Detective Thorpe is speaking, and he says, so let me ask you this. Of all them, I think he said clowns. Of all them clowns you just named, who do you think the first person I should go after? Mr. Copeland responds, to lock up or to talk to? Talk to. I would say Doo-Wop, but if you go after him first, they're going to have a feeling somebody told. You feel me? That's an opinion. Detective Thorpe, so who you think I should go after first? Mr. Copeland says, truth be told, I want to say Shannon. You feel me? Because when he said this indiscernible, I think it says got locked up. Because when we got locked up, Shannon looked like he wanted to tell. You know what I mean? Tell on them. Again, an opinion, speculation on the part of Mr. Copeland. Detective 1, yeah, but that was years ago. How you feel about little D? Like since D was the one that supposedly wasn't shooting, but he came and told you, Ms. Copeland says, D thinks he's hard. This is opinion. Detective 1, so he probably wouldn't just because he thinks he's hard. Mr. Copeland says, right. When I gave him your number and then y'all let me go. I was looking at him like, damn, D, like he the one, he knows I gave him your number, bruh. You ain't have to go tell everybody. Detective says, right. Copeland says, you know what I'm saying? Like he indiscernible on me. That's a little further. I think it stops at line 3. But it's clear that that whole colloquy from the previous page, 510 to 511, is all a matter of speculation. What the detective is asking Mr. Copeland as to who they should go after first, either to talk to or to arrest, there's no way that there's any relevance to that. Mr. Copeland's opinion, speculation as to who might talk or who might not, regardless of what he knows about those individuals, is in fact speculation, it's opinion, and it's not relevant. So my objection to that colloquy on that page and a few lines would be that it is improper speculation, impermissible speculation, and irrelevant opinion, and it should be redacted. It simply has no relevance whatsoever.
All right, sir. State.
Yes, Your Honor, this is very relevant. Again, the defense's theory about this case is that they didn't do any investigation. They didn't do anything. All they did was take what Copeland said and ran with it. And what this shows is that the detectives were trying to speak to other individuals in order to corroborate what Copeland told them. And so they are asking Mr. Copeland his lay opinion on who out of these individuals he should talk to. So I know we keep throwing around the word speculation and opinion, but a lay witness can give their opinion if that opinion is rationally based on the perception of the witness, which is 24-7-701. Mr. Copeland knows the individuals to whom he's been talking about. He has spent time with them. He is friends with them. He considers some of them like his brothers. We have pictures of them together. So he can, based upon his own opinion, can say, this is who I think will talk to you all, based upon his interactions and his lay opinion, Your Honor. So the fact that he tells them, here's who I think you should talk to, here's who I think will talk to you, is a proper opinion that he can give. And it's clear that it's an opinion because he talks about Doo-Wop versus Shannon versus Demikion. And he tells them, here's who I think you should go to first. But if you go to this person first, they're going to know that I told something.
Can I ask you a question?
Yes.
Or hijack you just for a second.
Sure.
Did you ask Mr. Copeland about this on direct already?
Ask Mr. Copeland
on direct about any of his discussions with Detective Dennis in regards to this part of the investigation. I don't recall it being asked.
About if he told the detectives who he should speak with in regarding this case. No, I don't believe I asked him directly that specific question.
Right, I'm gonna exclude it for foundation right now. I'm not saying it may not be admissible for other reasons later, but I agree with Mr. Adams. It is speculation and opinion is not relevant under 401 at this point in time. However, having said that, if somebody opens the door as to it, or if you continue with your direct examination, lay a foundation as to ask him any about that, then I'll reconsider.
So I guess my question is, if I ask him, did you advise law enforcement who they should speak to? There's going to be a lay opinion objection. When I'm saying it's not a lay opinion,
Well, it still might be speculation or opinion because it's got to be based on something. You're saying it's based upon he knows these people and he's got them, but you'd have to lay the foundation to ask that question.
But I think we have laid the foundation, or we've established.
Here's the thing. I don't think you get covered because he says, I don't recall, or I don't remember. I think you still got it, as I mentioned to you yesterday. With all due respect, you still got it since you haven't asked him about it yet. It wouldn't be proper to just play this. However, if you can lay the foundation based upon the argument you just told me, I'll certainly consider it at that point.
And I guess I want clarity because I think we've laid the foundation that he would have a proper basis to give a lay opinion.
I
So
don't know.
we believe that.
I need to, again, if you lay foundation as to a lay opinion, I might be able to rule upon it. I don't know whether or not that will carry the day or not, but it depends on on how you ask Mr. Copeland those questions and his response. I'm not, like I told you, I'm not saying that it may not be, but not right now.
All right.
So I'm gonna exclude that for the time being for foundation, but in the arguments of Mr. Adams. And like I said, I'll come back to it if you remind me at the appropriate time, and we'll look at it. Okay?
Yes.
All right. And,
Can I get the timestamp?
yes.
That is going to be 5:54:22
5:54:22
through 5:55:19.
5:55. 5:55:19. All right. Any further discussion? Okay.
The last one, Judge, is page 512, line 18, to page 517, line 19.
And you're right, based on your previous ruling, I think that this covers that same area about who they should speak to, so given your current ruling,
Okay.
the state will just address it at that.
Let me have the time. Let's have the time markings as well. So that will be excluded for foundation as well at this time. At this time.
And that was gonna be the same one.
Okay. All right.
Timestamp
5:56:18
5:56:18
through 6:03.
So what is that?
6:00.
6:00. Okay. All right.
That's it, Judge. That's all that we have on behalf of the board.
Okay. Before I return to Mr. Sharp for the two ones that we may have, and I think I asked the state about those. So let me get to that place and let me get to it. And I think that there's two that we may need to discuss or talk about again in regards to your client, Mr. Stillwell. Mr. Weinstein, anything else in regards to June 10th interview? All right. Mr. Matthews Jr., anything else in regards to June 10th? Okay, and good morning, sir. All right, Misty Williams. All right, Mr. Botts, on behalf of Mr. Nichols, all right. Okay. Anything further? Now I'll turn to Mr. Shark.
Yes, sir.
I think you were going to take a look at your notes or whatever in regards to for two particular areas. So have you done that so far, sir?
Well, I think we tabled it to, I don't know if I was necessarily going to look at my notes, but I've given those issues some thought, but I think we tabled them for further discussion.
Are you going to wait until they're played to object, or do you want to, can you identify them for me so I can rule upon them?
I have them, Your Honor.
Okay.
I believe it was,
Tell us what the page reference was, Ms. Hilton.
I think it's page 361.
That's line 1 to 362, line 10.
No, I have line 15 through 17, Your Honor.
That's the one where I think it's problem is Shannon. Is that correct?
Yes, and I believe the court wanted me to go back and listen to and determine if I asked questions.
Yes. And, all right. That was one. Okay. And did you review that, madam? Yes,
Your Honor. And that's consistent with the portion of the transcript that I just recounted in the argument with Mr. Adams about when Shannon got into the vehicle. Again, Mr. Copeland's current version of facts on the stand is that Shannon got into the vehicle with him and little D at the McDonald's.
All right, let me take a look at that right quick again.
This is regarding page 361.
Yes, line 15 through 17. And I believe the portion that's at issue is where he says Shannon shot Nut is what the court wanted to hear if I had asked him questions about the murder of Donovan Thomas.
Can I just go back and make sure we're on the same page with everything leading up to this? Because, Your Honor, I know what Ms. Hilton's speaking of, but I also had in my notes 361 through 10. So can I just confirm?
361 line 1 through 362 line 10.
361 line 10 to 362 line 10.
Okay, I originally had line 1. All right, so okay.
So 361 line 1 through 12, we'll say, the state has agreed that that's coming out. Is that correct?
No.
Okay, so all of this is in dispute, right?
No, from what you gave us originally, the only thing that was in dispute was Shannon shot up Lil Wayne's tour bus, Shannon shot Nut, Shannon does whatever Thug says.
On my list, it says page 361, line 1 to 362, line 10.
All right, so is the state agreeing to a portion of this to be redacted, or what are you saying?
The only portion that we agreed to be redacted is on line 16, Shannon shot up that tour bus.
Okay.
Line 16, and that's on page what, ma'am?
Page 361.
All right, and
it says the specific sentence is Shannon shot up that tour bus. And I believe, Your Honor, on Monday, you were holding off ruling to determine whether or not I had asked Mr. Copeland about the murder of Donovan Thomas. And you wanted me to confirm with Madam Court Reporter that I did ask Mr. Copeland while on the stand about the night of Donovan Thomas's murder.
All right. Specifically, what did you ask him? Because I do recall you did ask him about that, but remember, it's consistent with my earlier statements, that what exactly did you, because this particular, let me just kind of, all right.
Yes. So do you mind if I keep my seat, Sharon?
Yes, ma'am. You can keep your seat, just as long as you speak in the microphone, that's fine.
Yes. So it starts after you left Mechanicsville. Did you go anywhere after leaving Mechanicsville from what you remember? Yeah. His response, yeah. Question, do you remember where you went?
This is your examination.
Yes, Your Honor.
Okay, all right.
Pick little D up. Question, okay, and which little D are we talking about? Answer, the one that always be with me. Is that the little D you reference as your son? Yeah. Okay, do you remember where you picked little D up? Where did you pick little D up at? Answer, at McDonald's. Where was the McDonald's? On Cleveland Avenue. And when you got to the McDonald's on Cleveland Avenue, was there anyone else with little D? Answer, just him and Shannon. Anybody else? Just him. It says have Shannon, but just him have Shannon. When you picked up little D, what did Shannon do? What mean? You said you picked little D up. Did you also pick up Shannon? I said I picked up both of them. Okay. When you picked up both of them, where did you all go? I blanked out after that. You blanked out after that? Why did you blank out? Because they were saying that I got a phone call saying I did something. Do you remember who called you? Yes. Who? Muntsung. And do you recall how he called you? Did he call you on FaceTime or did he call you on the phone? I don't know. He asked me what I got going on or if I heard what happened or what. I don't know what he said. I just know he said that. I mean, people saying I killed Nut and he was calling me. Now let me ask you this. Did you kill Nut? Huh? Did you kill Nut? No. Okay, now when Moonsoon called you, was both Shannon and Little D in the car when Moonsoon called you? Huh? Was Shannon and Little D in the car when Moonsoon called you? I think so. Now, before Moonsoon called you, did you, Shannon, and Little D have any conversation about Nut being killed? No. Now, after you got off the phone with Moonsoon, did you and Shannon and Little D go anywhere? Huh? You said you were on the phone with Moonsoon in the car. I blanked out. Like, I know I ended up in a whole lot of places. Every time I looked around, I was somewhere different. Okay, later that evening, as we talked earlier, did you go to the police department? No. That night that you learned about Nut's death, Moonsoon called you. At any point, did you go to the police department? Oh, yeah. And then I believe at that point, Mr. Steele may have objected. And then I go into, on the morning of January 11th, did you ever speak with police? There was another objection. I asked the question again on the morning of January 11th, did you ever speak with police about Nut being killed? The police called me. Did you go to the police department? Same objection. Did you go to the police department, speak to the police? Yeah, I think. I asked them, how did you get to the police department? I dropped him off. By who Moonsoon got me, I ain't for sure. I can't recall. But I think who dropped me off, I just remember my brother and then met me down there that night. I said, now, Mr. Copeland, today being June 13, 2024, prior to today, I want to make sure I understand. Have you ever told police that Little D and Shannon got into your vehicle? Mr. Steele objected. The objection was sustained. Is today the first time you told the police or told anyone? And then the court interjects at which day? Today, June 13th. Let me strike that. Yesterday, did you tell me and my colleagues that Shannon, objection leading? I'm going to overrule the objection. Yesterday, did you tell myself and my colleagues, Ms. Love and others, about Little D and Shannon being in your vehicle the night of the murder? Huh? Yesterday, did you tell myself, Ms. Love, and a few of my other colleagues that Little D and Shannon were in the car with you the night of Donovan Thomas' murder? I told you and them that what I told the investigators when Nut got killed, something different, because I was trying to finesse my way out of the situation. Okay. So I said, I picked up D and Shannon. D never told me nothing. Okay. Was that yesterday that you said that? Did you tell us that yesterday what you just said? You asked me to be truthful. That And that's the end of the transcript as we have it. So again, he told me in court that D never told him anything, nothing. So anything that D told him that he told police D told him would be impeachment by prior inconsistent statement, impeachment by contradiction. He said, I made it up to clear myself and that's it.
You sure?
That's not true. The state's skipping a step. It's first of all, impeachment by contradiction is bringing in, it's not supposed to be prior inconsistent statements. That is.
No, it's anything that the witness testifies inconsistently with earlier. I mean,
Well, respectfully, that's what prior inconsistent statements are.
It can be.
Contradiction, Your Honor, is witness named Jeff says the light was red at the time of the crash. You bring in witness Brian that says no, the light was actually green at the time of the crash. That's impeachment by contradiction. You bring in another witness to testify about how the first witness was incorrect or wrong or contradicting. Prior inconsistent statements is a type of impeachment contradiction using a witness's prior statements. And so what the state is missing here is they're saying, did Demekian, they're saying the foundation is laid by saying, did Demekian, was Demekian in the call? Did Demekian say anything? Kenneth Copeland is saying no. But that's not the correct question to lay the foundation for prior inconsistent statements. They need to say very specifically, they need to ask, did you tell police that Demekian Garlington told you this on this date? That lays the foundation. And they're also confusing the issue by including Shannon in these conversations, which has never been said by Mr. Copeland. So if they say, did Demekian and Shannon, did you tell the police that Demekian and Shannon told you that so-and-so, whatever happened on January 10, 2015, he would be correct to say, no, I never told the police that. And there would be nothing inconsistent because he has never put Shannon as a party to any of these conversations. They need to specifically ask, did you tell the police, not did it happen, but did you tell the police that Demekian Garlington told you this? And if he says yes, then they don't get to get in these prior statements because they're not inconsistent. The question isn't, did Demekian tell you this? It's, did you tell the police Demekian told you this? And if he's asked that question, he may very well say, yes, I did tell Demekian that. It was all I did tell the police that Demekian told me that. It was all a lie, but I do acknowledge telling the police that. In which case, there's no prior inconsistent statement because he is acknowledging that he made that statement in the past, and it doesn't need to be proven using extrinsic evidence, including a videotape. But they haven't done that. They've just asked, did it happen? Not did he tell the police that it happened.
What if, as in this particular circumstance, I think that there's an omission. Like he says, hey, I don't recall this, and then his earlier statement says, includes more people or is more or has more granularity.
Well, the problem is they asked, did Demekian and Shannon discuss this in the car? And he has never said Demekian and Shannon discussed anything in the car. He said, what he said in his prior statements were, I showed it at the McDonald's. Demekian was the first person to come to my car. Demekian got in my car, said something very quick, pointed at the people who he said did it, and then didn't say anything else. That's what he said. He never said Shannon Stillwell was in a car discussing anything. And the reason he never said it because Shannon Stillwell was never in a car discussing anything. So be very specific about what they're saying he said in the past. And if he owns that prior statement, then this doesn't get in.
You're right, but that's the point, Your Honor. We agree. He never told the police that Shannon was in the car. So he is contradicted by what he told the police previously. And he said, and I don't have to ask him again, His answer was, I told you and them that what I told investigators when Nut got killed, something different because I was trying to finesse my way out of the situation. He has already admitted right there that what I said to the detectives in 2015 is a lie. It's not true. And it's inconsistent with what he is now saying in what he said back then. So that's a prior inconsistent statement. Furthermore, to address what Mr. Shar just said about extrinsic evidence, when it comes to impeachment by contradiction, impeachment by contradiction occurs when a party offers evidence to prove that a fact to which a witness testified is not true. And it can be done by extrinsic evidence. The recording is the extrinsic evidence that we can bring in to show that what he said in court is not true. This is the extrinsic evidence. It does not have to be another person. The law does not say you have to bring in another witness. I can bring in extrinsic evidence. That is the recording of him in the interview room telling the police what he said.
All right, Mr. Shard, I'm gonna admit or allow the state to play that particular portion from page 361, line 10 through 362, line 10, as impeachment by contradiction. I'll give you a over defense objection. I'll give you a continuing objection as to that, sir.
Minus the.
Oh, of course, minus the 361 line 16, Shannon shot up that tour bus.
Whoa.
That will be excluded.
What about?
Before you go on, can you give me the time reference, madam? Time, video and audio time.
So for the portion that is out is 3:29:37 to 3:29:39.
Okay. And the balance is from what time to what time, exclusive of those at that time period?
So it'll start from 3:29:20 through 3:29. It will probably stop at 36 to make sure that we do not get into
Okay.
the middle part, and then it will pick back up again at 3:29:41.
All right, Mr. Short, anything, you were going to mention something else, sir?
And I understand your ruling as it applies. I respectfully disagree, though not waiving objections, but I understand what you're saying about he shot the gun and killed Nut. I don't understand how on the theory of impeachment by contradiction or prior inconsistent statement, how this part gets it. Thug, this is Kenneth Copeland. Man, whatever Thug say to these ends, Shannon will do it, man. Every time Thug say something, Shannon do it. Like now, if they want to get into the Bloody J thing again, I don't think he's denied anything with the Bloody J. I don't think he's testified to anything different about the Bloody J. He said Bloody J was beaten up. So I say that and beat him up. So those statements, I get what the state's arguing about the killed Nut. But those other statements, they're just bad character, generalizations, not inconsistent with anything he's testified to on the stand, not inconsistent with anything that he's been confronted with on the stand.
It's the respectfully, it's the conversation in the car that the jury decides whether or not they believe it or not, whether or not the version that they believe was the one that was done on the 10th of January of 2015, or on the stand on or about June the 10th of 2024. I think it's impeachment for what he didn't tell them in the car. Well, one, that he wasn't there, or two, what he said in the car. So I think that's what the impeachment's for.
But when he says, like, man, whatever thugs say to these ends, Shannon will do it, man. Every time thugs say something, Shannon do it. That's not anything that was discussed in a car.
State.
Your Honor, so two things as to relate to that portion. We have charged Mr. Williams with a leadership charge. So this directly goes to the fact that anything that the leader says, Shannon does. So that directly addresses the leadership charge that we have charged Mr. Williams with in this indictment. Furthermore, Your Honor, again, when Mr. Copeland has said everything that I told investigators regarding the night of the murder, regarding anything I told them, I was telling them anything to finesse my way out of going to jail. This would be in contradiction to it because he's saying that's a lie. Now, if the court would like, and I have no objection to asking him specifically, does Shannon do anything that Mr. Williams says, and then playing this portion, I have no objection to doing that.
I mean, but
it is important because we have charged Mr. Williams with the leadership gang count in this indictment.
It's all speculation, and I understand that the state feels it's relevant because they've named that Mr. Williams. They've asserted that Mr. Williams is somehow a puppet master over everyone, which isn't true. But beyond that, just because they've asserted it doesn't mean all types of everything is admissible. It still has to be based on personal knowledge. It can't be speculation. And so, yes, they're asserting, okay, it's relevant because this is the way we charge the case, but that doesn't solve all the other evidentiary issues with. And again, we're not even talking about something that the man's saying on the stand. We're talking about it being played in a tape, out of court statements. So just because the state has indicted something a certain way doesn't mean they just get to play a bunch of tapes that fit their narrative.
Yes, sir. I'm still going to admit it for its purpose. Over your objection, I'll give you a continuing objection, sir, as to that respect.
Yes, Your Honor.
All right. We have one more, madam.
Yes, Your Honor. And that was for page 386, line 20.
386. Hold on one second. Let me see if I can find it. Okay, you said 386.
Yes, Your Honor.
Line. I'm sorry. Line. 2.
Page 387, line 12.
Okay.
And Your Honor, I believe this is Mr. Copeland was discussing. Mr. Copeland was discussing the conversation that he had with Nutt prior to Kel. The discussion that Mr. Copeland had with Mr. Donovan Thomas Jr. regarding Mr. Copeland's differences with Shell Kel or Kelvin Watts. And the court wanted to know specifically if I had asked Mr. Copeland any questions about whether or not he had ever spoken to Nutt. And we were able to find in the transcript that I did ask him a specific question, and I can read that portion to the court.
All right, go ahead. What did you ask him?
So it starts with, do you recall telling Detective Thorpe that Nutt was somebody you could talk to? I don't know nothing about all that. Okay. Do you remember? I don't know. Yes, I said it to him. I don't know. Do you remember telling Detective Thorpe about the last conversation that you had with Nutt? I had a conversation with Nutt. Do you remember telling Detective Thorpe about a conversation that you had with Nutt? I don't remember what I told Detective Thorpe. Do you remember telling Detective Thorpe that when you saw Nutt, he just told you to chill out and just And then there was an objection by Mr. Steele. He said hearsay. Court sustained the objection. I responded, it's going to be effect on the listener. It's going to be what his response was. Judge then overruled the objection. And then I asked him, and that you told none, I'm just trying to get money. Was I supposed to say that to the police? Yes, I told the police. Excuse me. I said, you told the police. He says, yes, I said it. So that was your last conversation with Nut? I guess, yes, I don't know. When you say you don't know, what do you mean? I don't remember what I told any police. I don't remember what I have told them. And Your Honor, this portion right here, when he says, I don't remember what I told them, it really opens the door to all of his statements coming in without me going in line by line. However, the state has gone back, but the case that I cited to the court yesterday, which I think was the Scudder's case.
Scudder case.
In which once
Sconyers versus the state.
Sconyers
318 Georgia 855 decided April of 2024.
Yes, Your Honor. And once he says, I don't remember anything I told the police, I do not have to go line by line to asking specific questions.
Not saying you have to do that. Not saying you have to do that. But I don't think it gives you carte blanche, as I mentioned yesterday. So does your questioning again indicate questioning in regards to Kel or Mr. Stillwell?
This line of questioning discusses speaking to.
On this, and let me be clear. From what Mr. Copeland was on the stand earlier, what did you ask him that on the stand when he was here several days ago that opens the door or allows you to play this particular part of the tape?
And this, it's not contained in this, what I have as a transcript, but I believe when I continue my questioning, I asked him specifically about talking to Kel. Now, I will take responsibility. I did not ask Ms. Weaver to give me the rest of this portion of the transcript, just solely the fact that
why don't I defer on it again until that'll be an outstanding one. You just need we will hold that.
Can I just clarify?
We'll hold that until the transcript is at least a little bit more readily available.
Can I clarify our stance, though, just so?
I'm sorry?
Can I clarify our stance to kind of crystallize the issue?
In terms of what, sir?
Well, the state is asserting that they've established a foundation to get into either impeachment by contradiction or prior inconsistent statements.
Well, not yet, Mr. Sharp. I'm going to defer on that until I hear whether or not they have in fact asked enough for me to even entertain this particular set part of the transcript.
That's what they're asserting. But just because they ask about
no, I agree with you. Okay, at this point. Well, I need to hear the statement first that was asked on the stand to make that determination. So that's why I'm saying let's defer it until that time, because I need to first hear what was asked, hear what his response allegedly was, and then determine whether or not it falls within an acceptable, if it does, exception for me to authorize them to play it.
Yes, sir.
Okay. All right. So just remind me, I'm going to hold that. Okay. All right. All right, councils, is there anything else in respect to any of the interviews involving Mr. Copeland as it pertains to interviews on January the 28th, 2015, February the 21st of 2015, or June the 10th of 2015, other than the one I've held?
No, Your Honor, and the state's intention is to take the transcripts that we have, highlight the redacted portions, send that over to defense counsel so they can confirm.
I'm just going to say that you will be doing that for the Thursday the 27th. and Friday the 28th. Okay, because I do want to make sure you all have a chance to look at that. Please don't come here and we get Mr. Copeland back on the stand, and then you all want to still argue about redactions that. So I want to know if there are any problems before we put him back on the stand or we resolve those. So yes, showing those. So defense counsel, is that acceptable to you?
Can I give it to them by Sunday? Only because, Your Honor, as the court may be aware, we have a full day of court with the other individuals on Friday. And so I'm going to work.
This Friday?
Yeah.
No, we're not.
No, not with the other.
Okay, yeah, that doesn't pertain to me. All right, so right now.
But it pertains to the members of the state.
One of my other colleagues. Okay, all right.
Yeah, so we
okay.
can have it till this weekend. We do intend to get it to them by no later than Sunday.
At what time?
Sunday by 5.
My suggestion is that, and you all can do this the way you want to, but you all need to probably look at this. You know, you probably need to play it, yes, or at least the portions I've ruled upon. You all need to get together physically or have a representative get together and go ahead and make sure that the edits are correct. Because what I don't want to do is play things that are outside the bounds of what we talked about, and then there to be objections and problems. So can I get somebody's commitment to do that? And if so, when are you going to do that?
We can do that tomorrow, like just to sit through and run through the times, and we can do that, right. And then the redaction, like with the actual transcript, I can get to get that.
All right, so defense counsels, are you okay with that suggestion? Well, who's gonna? All right.
So objecting to the
just generally, Mr. Steele. I know that you don't believe a foundation's been laid, and you believe that it is improper impeachment as a whole. So that is not lost, and that'll be your overarching objection, which I'm giving you and others a continuing objection for. But since I've ruled, to the extent that I've ruled on the parts that need to be omitted, that's what I'd like you all to at least make sure that occurs.
As far as I'm concerned, Sunday is fine. That's what the state asked for.
Okay. Is that for the transcript, or are you all going to actually physically get together and look at the video and and audio to make sure it matches?
Can I ask, is the state planning on taking the segments out so it jumps from one to the next, or is the state envisioning just turning the volume off?
We'll turn the volume off only because when we tried to convert it, and I think you all had the similar issue, it jumps. The video itself is not it's not good video. Unfortunately, when we try to convert the evidence reviewers to MP4s, it doesn't. It's not good video.
Okay.
To do that. So we can plan to play and stop. Now we can, if defense counsel on their own wants to verify the times, and then we can verify the times, just make sure that the times are consistent. We can do that as well. If they would do that on their own, and they can just forward us the times, we can do that as well. But we're open to whatever way to make sure that we don't have any issues.
Okay. And Ms. Steele, you said, or Ms. Sharp?
Speaking for myself and I think others, we don't know the technology involved, but we object to presenting it, just playing it, and then turning off the volume for certain segments, and then turning the volume back on. I think that invites the jurors to believe that something's being hidden from them, invites them to assume that it's they're not getting evidence concerning our clients, and invites them to draw negative inferences from that. So we would object to just turning off the volume and letting the video play. I'm not sure about the technological challenges. Someone that's smarter than me, I'm sure, can find a way around that, but that's our stance.
Yeah, I think the court will instruct the jurors that they are only to consider admissible evidence. And so what the court has ruled or deems that portions are not admissible, or that the state doesn't intend to play it. And there are portions that the state doesn't intend to play that defense counsel may or may not play. And so if we redact portions and make it seem as if there's one interview, the jury may get confused if there's a portion that the state redacted that now becomes a part of evidence when the defense decides to play portions if they choose to play it. Now, we've already been doing this in this method. This has not changed. It's nothing different than what we've already been doing.
Okay. Mr. Shard, I've noted your objection for the purposes of redaction. I'll just, at this point in time, given what we've done earlier and the challenges that we've had, we'll just turn the sound off at that particular period. And we'll do the best we can with that. All right, anything else? Okay, as it pertains to those 3 interviews. Okay, because Mr. Weinstein's got that look again. We're going to go ahead and recess for a break and for lunch. Let's come back, councils, at about, let's just say 1:15, and we can go ahead at that point in time and take up the jail calls that Ms. Hilton has. We'll identify the email, take up the jail calls that she plans or that the state plans to play at this point in time, and we'll see where the day leads us at that point. Okay. All right, I'll see y'all at 1:15, all right? We're in recess.
Really? 100 million bucks is a pretty good
subsequently released under Mayorkas. By the way, he was covered in gang tattoos. They knew exactly what he was, but Secretary Mayorkas's his leadership, these
the jail calls that the state wishes to play at some point in time during Mr. Copeland's examination. I'm going to include as the next court exhibit in order the email sent from Ms. Hilton to all of you on Tuesday, June 25th at 7:54 p.m. All right, so Ms. Hilton, from your email, it looks like that there are 5 calls that you initially provided 11 calls, but these are the 5 calls that you are definitely going to play, and the other 6 may become relevant at a later time. And that you say during your email, these do not cover jail calls that you intend to introduce to other witnesses later in the trial. So these are just the ones most immediate that you believe you're going to use to continue with your examination with Mr. Copeland. Is that correct?
Yes, Your Honor.
Okay. All right. So given that backdrop, I think the first one that you indicate that you are going to play is you have it marked as Index 58, March 11, 2015 at 19:27, and it goes from 00 to about 15 minutes and 30 seconds. Is that about right?
Yes, Your Honor. At this juncture, we haven't heard any objections from the defense.
Well, first, let me find out. Do we have any spokesman, or do you want me to ask each individual defendant? Yes, sir. Okay. Of Index 1, I'm using Ms. Hilton's email for purposes of this discussion.
And Your Honor, it will be State's Exhibit 401.
I was going to ask you that next. Okay, it will be State's 401 Yankee.
Yes, Your Honor.
And Mr. Steele, what's the part that you have an objection to?
Mr. Copeland is asking for a lawyer. I believe the state alleges that he's speaking with Mr. Jeffrey Williams for a part of that call at about that time, and that Mr. Williams uses my name, my first name, on the call. I would object and ask to redact that portion, especially my name.
Okay.
Your Honor, in listening to that call, I don't believe he said Brian.
Can you play it?
What's the time?
Can you play maybe play the last 2 minutes? Would that be sufficient for me to listen to it, Mr. Steele?
Yes, sir.
Okay. Let's play the like 13:30 to the end.
Okay.
Okay. 15:30. Oh, thank you. Thank you.
Oh, sorry. That's not the right one.
Hey, wait.
You go.
13:50. Okay.
Look in your eyes. Yeah, they say.
Your Honor, we're gonna start at 13:30 or 13:33 now.
The police, let them jump on me. I see Nick crazy, man.
Man, whoever has so many problems, whoever in the jail, all that jumping, that's what's your intent, man. What's your intent, man?
This shit here a drag, bro.
Man, what the hell you talking about? You already know I know. You already know I know what's happening. So y'all out there, I was already like, what the hell? What they talking about? Now I'm talking about nobody. Then what I'm trying to tell you, man, I don't stop right here in front of these folks and look at these folks call that shit on the phone. Yeah. You better call her. Like, call her. See what the fuck going on. Because the probation, it's just a little bullshit. But the probation will try to hold you. Just about their money or whatever. So I already know that. Like I said, I would just gave my lawyer the 3-4 band, $2,500. You know, he'll bring you.
You have 1 minute left.
They get you in the courtroom for $2,500. You know, that ain't shit.
I don't even want that much. One lawyer had so.
I know.
Yeah. So listen, I might have this son text you my information and stuff. You say you try to have it in the morning.
Yeah, I had a lawyer or whatever lawyer you choose.
I don't have none.
Well, I could just have somebody pull up on their son and bring their son the money. Then you see what I'm saying, or they son, mom or daddy, because you know they probably know something about the shit. So I can just make anybody go get the money. I can make them pull up to the club, get the money from Ken or anything. Right now, you see what I'm saying? So that ain't no pressure.
Shit, we don't know no lawyer though.
Yeah, you know what I'm saying? You know my lawyer.
So
I know mine. I ain't got the number. Hit him.
You
just tell him. Yeah, he already got my card and everything. He already got my card and his system and shit. So I ain't got the number. Just hit him. Like, go check on this number right here, and then go check on this name. And
Thank you for using Securus. Goodbye.
I did not hear Brian or Mr. Steele's name at all.
Mr. Steele, I can't say I've heard it either. Do you have a time reference you can point me to again? I'll listen to it again.
15:12 is what I'm being told.
Okay, let's play about, please.
Hello.
Oh. Chris, can I listen to this too?
Yes, you
Okay, all right. Council, I'm going to listen to it through the ear audio system. You're welcome to listen to it as well again.
And it's going to start at 15:04.
Go to the club, get the money from Ken or anything. Right now, you see what I'm saying? So that ain't no pressure.
Shit, we don't know no lawyer though.
Yeah, you know what I'm saying? You know my lawyer.
So
I know mine. I ain't got the number. Hit him. Just tell him. He already got my card and everything. He already got my card and his system and shit. So I ain't got no number. Just hit him.
You can stop it. It
go
does
check on this number right here and go check.
So.
You're right. That's fine. We can stop it right before that portion.
All right. Mr. Steele, any further? They're going to edit. They're going to not play that. I do hear your name. At least what's represented to be Brian. So that will be excluded. Does anybody else have any specific objections as to any other period of that call from 000 to 15? About 15 minutes, 10 seconds or thereafter. Mr. Weinstein. No, Your Honor. Mr. Matthews. No, Your Honor. Ms. D. Williams. All right. Mr. Botts on behalf of Mr. Nichols. All right. Mr. Short. No, Your Honor. Okay. Anything further, Mr. Steele? In regards to that section.
Not the part that you just ordered to be staged or not played.
It's not going to be played.
I want to be clear that we're not just playing his name, but the fact he says, you know, my lawyer, and we'll stop where it says, before it says Brian. And then we'll play after that as well.
All right.
I don't know the relevance. And then it gets cut off. So I'm objecting to that.
To the relevance of, you know, my lawyer.
Yeah.
Or that part of the tape?
What difference does that make?
Okay. State?
We believe that as a part of the RICO conspiracy, the fact that the leader is offering up his lawyer to pay for another co-conspirator to gang to get out of jail is relevant information. Who it is, that's fine. But the fact that he's offering up his lawyer for another co-conspirator is relevant.
Mr. Steele, anything else?
Yes, it was a conversation that got cut off. If you look at the records, or if the state bothers to look at the records, I did not have anything to do with Mr. Copeland ever. I don't know who represented Mr. Copeland, so I believe that it is irrelevant. It's just a conversation that was then cut off. So you don't get the entirety of the thought. So if they're going to argue, they being the state's going to argue, oh, Mr. Williams is going to use his personal word. That's not a true statement, so it's misleading. It's an incomplete, it's unfortunate, but I don't think anyone did it. But I think the securist cuts off at
15 minutes, yeah. The other thing is, I think that, well, the court heard there's some conversation prior to that, because we played the last 2 minutes in regards to representation. So I think that's what it's made in reference to, even though they don't complete the conversation. But Ms. Hilton, anything else?
That would go to weight, not admissibility. He can surely ask, if he chooses to ask Mr. Copeland any questions, did you ever get a lawyer? So he can ask Mr. Copeland that question.
Mr. Steele, anything else before I rule?
I just don't think it's needed to say my lawyer. That's what I'm objecting to. I don't mind the conversation about, I need a lawyer. I think Mr. Williams says, get any lawyer you want, something to that effect. It's not a quote. But I don't see the need to say, I have my lawyer, I have his business card, I can call my lawyer. I don't see how that is relevant. And then it gets cut off. So I don't know if that means what the state is saying is, oh, and then he's going to get his Mr. Williams personal lawyer for Mr. Copeland. That's not what it says.
And that would be certainly speculation.
That
would be speculation, but I think they get at least to play it based upon what they proffered so far. I think they get to play it as subject, and also it's very limited as to what it can be said about it, because unless Mr. Copeland, has some frame of reference, but.
I don't disagree with that, but I would like to leave it after I need money for a lawyer. These are not quotes. But, they're discussing, I need money for a lawyer. I don't know any lawyer. A statement is made, we'll get any lawyer you want, and then just end it there, rather than I have my own lawyer and I have him on Rolodex or whatever I don't think Rolodex would use, but whatever those terms are, at that point I would end it. That's my request to the court. I also object.
Let me see if the state has any
Your Honor,
further issues to that.
Your Honor, relevant evidence is any evidence that tends to prove an issue. We believe that the fact that the leader of the gang is offering up his lawyer to his co-conspirator is relevant for this jury to determine whether or not there is a RICO gang conspiracy. And so we believe that is relevant, because the argument is relevant. It also comes in because it's a party opponent admission. This is the defendant Williams telling Mr. Copeland that I will provide. He said, specifically what Mr. Copeland says is, I don't know any lawyers. And he said, you can call my lawyer, is what he actually says. So I think reading it in context, he's saying, okay, you don't know any, but I'll provide mine, or you can potentially use mine. Whether or not he used him or not, that is a question that can be asked of Mr. Copeland. But the fact that he was willing to offer up the lawyer is what is important, not the result of it.
All right. Sir.
I think this is a very bad point in our community if we are now going to say offering to get someone a lawyer is part of a RICO conspiracy. This is a probation revocation case on supposed non-compliance with community service. I know you haven't heard the whole.
I haven't, sir.
That's what the recording before we started at 13:30. That's what it's about. Mr. Copeland says, and it basically mirrors what he said on the witness stand. He said, the police had me locked up. These are my words, trumped up charges because my probation officer didn't take out a warrant on me, but the supervisor was asked by the police to take out a warrant on me because of community service hours. I will be getting out on Friday. This is a Wednesday. I'll be getting out on a Friday, and I believe it's a Wednesday. I'll be getting out on Friday when I go to court, but I don't have a lawyer, so it gets continued for me to get a lawyer. So I'm held hostage basically by the way the courts are. So Mr. Williams is not part of any of that conversation. He then allegedly gets on the telephone and has a conversation, and that is explained to Mr. Williams as well. I go to court Friday, but I don't have a lawyer. To then say that it's part of a conspiracy to get a lawyer for someone going to court on a probation revocation case, I think is a bridge too far. To say you're going to get a lawyer, I don't have a problem with that. But to say I offered up my lawyer because that is symbolic of a crime, seems to me that if that type of evidence comes in courts, we are all in trouble, because that's what we want people to do. We want people to get lawyers. So I'm objecting to the state's playing that portion. I'm not objecting to the portion that Mr. Williams allegedly is on the phone and is offering to potentially help with a lawyer. I don't have a problem with that. If the state wants to then argue that's somehow part of a conspiracy, I'll argue against it. But to then go further and say, aha, and this is the crime organization and the lawyers are part of the criminal activity, I think that is under 403. It should never be said in any courtroom unless there's proof of it. That lawyers protect criminal parties.
Your Honor, the state never said, I don't even know where Mr. Steele got that last assertion from. The state said what is relevant is that he was willing to offer up his attorney to represent him. That is where it ends. And everything else Mr. Steele said is great for closing argument. But the relevance of it, it comes in, and then he can argue all of that, what he just said in closing.
It's relevant. It's more probative than prejudicial under 403, and I'm going to go ahead and I'll allow it. I'll give you a continuing objection, Mr. Steele, in that respect. Okay. All right. So what was the next thing you wanted to argue about, sir, or have me invite my attention to? As to the first call. Is it the first call or another call?
This is this call, but it's going to be for all of the calls.
Okay. All right.
There's portions of it that are just conversation about what other people said. I'm just using an example. Val, V-A-L, said that, and have 1 second.
In this call, Mr. Steele, or a different? Oh, I'm sorry. I don't. Your Honor, if you could ask, are we addressing the March 11th call?
I was gonna ask him for that clarification myself. Mr. Steele said it was this call and other calls, but he's making for example, and I think he mentions Val at that point in time, but I wanted to find out, is Val on the first call, second call?
I think this June 10th call, which may be the second call.
Yes, June 10th. That's the one at 2038, 4212, 10, 44. I'm sorry, 4 minutes, 12 seconds, 4 hours. Is it four? Is it hours, minutes?
It's 4 minutes and 12 seconds to 11 minutes and 10 seconds.
Okay, thank you.
But so can we just either close out or finish March 11th? So we can
all right.
But the state will ask.
I was attempting to say, but it's going to be overarching, but I could do it individually. So on each call, there are conversations about what did someone else say. So Mr. Copeland, allegedly, his voice is speaking with his girlfriend or significant other or the mother of his child. And he is saying, what did this person say? Well, this person said A, B, or C. I am objecting to any that is hearsay. So for instance, in this call, Shannon said something. I'm not saying, Mr. Sharp and Mr. Botts can handle that for Mr. Stillwell, but I'm objecting to any third-party hearsay. They're not even on the call. I understand also that if Deshawn is not being called as a witness, which I believe she is not, I'm sorry, I shouldn't say the significant other of Mr. Copeland, I do not believe the state is going to call her. I don't know why her voice gets to be played on these recordings, unless she's somehow an exception to the hearsay rule. So I tell you that, Your Honor, because that is infected on each of these calls, because clearly there's another party on the call.
Another party that Mr. Copeland's talking to?
Who will not be testifying and who has not been classified so far as a supposed co-conspirator.
So, Your Honor, before we even get to these generalities, we can just talk about each individual call, because I think it becomes confusing and timestamped, so we can know what you're objecting to and the basis of your objection, because some of what Mr. Steele is referencing, there's exceptions to why this should come in. And so I think that we need to take call by call what is being objected to, so we can respond accordingly to that particular section.
You all have transcripts of these calls?
We do not have transcripts of the jail calls, but they're clear enough that you can hear what the issues are.
The challenge that we're going to have is, without a transcript, I'm going to have, unless you've identified that already, or this defense, Mr. Steele, I think you all are going to have to identify that, because what's going to happen is, if it's played, we're going to end up having this continual objection and potentially putting our jury out for periods of time to have me adjudicate that. So is it possible for you all to listen to the tapes, to the jail calls, and then flag those portions like you did for his interviews, to have me rule upon those? Because I understand what you're saying, Mr. Steele. It's a valid point. But what I don't want to do is, I want to minimize the disruption in front of the jury. So if we have an agreement, then, or if you need to just object, I'll say as earlier noted. So yes, I think that would be a much better way to potentially present this.
I could have that. I didn't write down the timestamps, but I can do that. So flag using the timestamp.
Yes. And then you could tell me, for example, to go to, 12 minutes and 15 seconds, it's hearsay, it's not within any exception, or it's speculation, or, whatever. And I'll let the state respond, and I can rule, kind of similar to what I did with the audio videotape interviews. If that's the case, I think that would probably be a better use of our time.
And again, Your Honor, the portions that we sent an email yesterday are the portions we intend to play. So there's only 2 calls that we intend to play the entirety of it, but the other calls, we've broken down specifically the areas that we think are relevant. And so,
okay, the first call is like 15 minutes.
So only the first and the 5th call are the full 15 minutes. The calls are 15 minutes. So only the first and the 5th, we intend to play the full calls. However, calls 2.
Is that the June 10th call at 2038?
Yes, Sharon. So in the June 10th call, the only portions we intended to play is 4:12 through 11:10, and then picking back up again at 11:45 through 15:26.
All right.
And then for June 13th, the only portions we intend to play is 00 through 6:05.
That's still a fair amount of time, though.
It is. So they definitely are, but I just want to make sure that they're not listening to the whole tape and saying, I want to just keep the guides of what we intend to play, so defense knows the parameters that we intend to play when they're reviewing it to determine to determine what they're objecting to.
Okay. Mr. Steele, give you just a thought. I need to consult with Mr. Chamberlain just a second. How long do you think that would take? And I'll just ask you when we come back on the record, okay? All right. I'm just going to recess in place.
time stamping and so forth. I think it's not.
Okay. All right. Okay, folks. I'll just direct Mr. Adams and Mr. Steele. You all go ahead and do that at this point in time, and then send what you feel you must to the state, and then we'll take it up either Monday the 1st of July or Tuesday the 2nd of July. As part, we left the Tuesday open anyways, the 2nd, to complete whatever was not done. So I think that we could probably handle that fairly comfortably on that morning of the 2nd, Tuesday the 2nd.
I think we're kind of ahead of schedule that we
Set.
Ahead of where we thought we would be anyway. That's fine.
Okay. All right. So let's just plan on taking that up Tuesday morning, the 2nd of July, when we start court. I'm gonna probably leave in probably about an hour. But tell me where you all are.
Would it be an impeachment on anybody if we got it in writing by tomorrow morning? That'd be okay?
That's perfectly fine.
That's fine, Mr. Steele. Let's say by noon tomorrow. Would that be sufficient?
No problem, yes.
Okay. All right. Okay. So we'll take those up on Tuesday, July the 2nd, 10 a.m. Okay, anything else we need to take up at this point in time?
Nothing from the station.
Anything from the defendants?
No, sir.
Okay. Monday, the 1st of July, as I mentioned earlier, we'll bring your clients over. They'll be here. I'd ask council to meet 8F jury room for Monday at 9 o'clock. All right? For the in-camera review.
And on that, Your Honor, again, and I know I said it, so I'm assuming that it's preserved, but Mr. Williams would like to be present.
Yeah, you told me that already. Do you have any additional case law other than the United States Sixth and Georgia's Sixth Amendments?
Georgia's Article 1, Section 1, Paragraph 12. I believe Mr. Williams, I need him there to review. I assume we're getting a transcript. I don't know if that's.
I'll cover that on Monday. Mr. Williams will be brought over, but the part that you all are here just for in camera, that's attorneys because of the privilege potential that is that may be discussed. Or, no, I said not discussed, identified. And you all as lawyers are of course subject to the rules of professional responsibility. Third parties or your clients and other people are not.
Well, I pose that objection.
And sir, if I have anything else, I will certainly reconsider that. But at this point in time, for that particular purpose, until we get through the in-camera review, I will. When the transcript is reviewed, the court's intention is to review everything for for Brady and/or impeachment. And then I will flag all those, and then anything else that you all wished for me to consider, I will then, and you can mark, and then we can have a discussion about that.
Okay, and I'd like it done in open court as well, in Mr. Williams' presence, of course, and in open court.
Okay, I don't think he can do, until I identify it, Mr. Steele, and make rulings on it, he doesn't have the right to be present. You're the person that's present for him at that point in time because it covers privilege. It's just like if you had defects records, okay? You and Mr. Williams could not come to my chambers and review those records. You could, but he can't. Now, once I've ruled upon those, of course, I will copy whatever periods of the transcript, portions of the transcript that I believe are appropriate, and I will make other rulings in regards to sealing that particular portions which are not. For any other review, and then you can take that to Mr. Williams, and all of you can talk about that.
I understand. I just.
I know you've made an objection as to that, as to your client's presence, but for the privilege or for the in-camera review, he doesn't have the right to be there. I respectfully disagree, but.
I understand that we are in disagreement, but I'd also like to then wait. Open courtroom, I believe that it should be done in open court as well, and that's under Article 1 and. Okay. The first in the.
I understand that. I agree with you about the open court. I understand about the open courtroom. I agree with you about the respective constitutional provisions. I disagree with you about the in-camera. That doesn't apply to an open courtroom. The in-camera review of these records. So we'll just, like I said, if you got some case law, you got something for me to consider, I'll certainly look at it. But at this point, that's what my ruling will be in terms of your client's collectively presence. However, like I said, once the court makes those determinations as to which things are to be released to you, and I copy those transcripts for you, those portions or the transcript for you, then your clients will be here and you may take those portions and discuss those with your clients. Okay, and then we will have the rest of whatever we have in open court. Okay.
Understand the ruling.
Okay. All right. Like I said, if you have some case law you want me to look at something, I'll certainly look at it because I
believe that under United States and Georgia Constitution and Presley, it's a voir dire issue, but I believe this should all be done in open court, not in a closed courtroom or closed chambers. jury room.
You are correct about anything else, but when you deal with when you're dealing with a matter of privilege and or depending upon the type of records you're reviewing, not everybody gets to see those. And that's where we disagree. That's not an open proceeding. That's a closed proceeding to decide whether or not what's going to be released. Again, I'm going to release to you what the court believes falls within the acceptable range categories of release. It may be the entire transcript. It might be portions of that transcript, but I'm going to listen to your argument about that. That you don't get an open courtroom for, because I have to make a determination of whether or not first you get it, and then whether or not what basis you get it for. Then once I release that, I make a ruling, which can certainly be reviewed at some point in time. Then I'm going to seal the rest of the record. I'm going to seal that particular ex parte because it will have some issues of attorney-client privilege. So that's why, or else I give you the entire transcript. It would be fine for me, but I think that that's the issue.
If an attorney-client privilege conversation was captured by the court reporter on a transcript with the court present, it can't be attorney-client privilege.
Well, that's for another body to resolve, not me. And you'll have to first decide whether or not those conversations were had. So once you take a look at the transcript, then we can have the conversation.
That's fine. I'm just continuing. I've voiced it, so I think it's preserved. But
I think you've said it now 3 times. I think you've gotten your point across. But again, I'm going to tell you again, if you got a case which says your clients can be present, I'll be more than happy to listen to you. I really will.
Well, my case is every case, but Penny, P-E-N-N-I-E versus State, Sammons, S-A-M-M-O-N-S versus State, Ward, W-A-D-E versus State, 1852. But the bottom line is, and they all say the same thing, at any critical stage of the proceedings, the criminally accused has a right to be present. I'm raising under federal as well as state constitution. I'm also raising an open courtroom, not a closed courtroom, under the right to public trial.
I understand that, sir, and I'll take a look at the cases you cited, and that is part of what the court has to rule upon, whether or not it was in fact, or whether or not somebody else will rule upon, not me, I should say, whether or not it's a critical stage. But let me get through the review of the in-camera review first, and then we can have some other conversations. Okay?
No, I understand how it works. I just object. You're overruling it. I'm just
okay. All right.
Thank you.
State, you'll be able to as well join for those of you that were in there as well. I believe Ms. Hilton and Ms. Love for that same review. Okay. Thank you. All right. Okay. All right, folks. I'll see you on Monday. All right. Enjoy the rest of your time. 572. Mr. Stillwell, Mr. Botts, and Mr. Shard. Good morning, gentlemen. All right, Mr. Williams, Mr. Steele, Mr. Adams, and Ms. Renard. Good morning. All right, Mr. Kendrick and Ms. Hingerty. Good morning. All right, Mr. Huey and Mr. Matthews Jr. and Senior. Good morning. Mr. Nichols, Mr. Harvey, Ms. Westmoreland. Good morning. And Mr. Ryan and Ms. D. Williams. Good morning. All right. Ms. Love, Mr. Atkins, Mr. Brown, Mr. Smith, and Ms. Hilton. Good morning. Good morning. All right, Sergeant Ingram, all our jurors are present? Yes, sir. Okay, is there anything I need to cover before we bring them out?
Very quickly, sir.
Good morning. Good morning, everybody. Your Honor, would you consider a continuing objection? The state is objecting on cross-examination oftentimes to, and I'm quoting, facts not in evidence. I researched that. That has only been used in closing argument and a hypothetical. So these are not hypothetical. So if it's okay with the court, can we have a continuing objection to any ruling sustaining that type of objection?
I'm not inclined to do that because there are circumstances where predicate facts have not been introduced before the fact finder, and that objection would be valid.
And then, okay.
So I have to rule upon it on a case-by-case basis because I'm listening to the testimony as well. So, so it is a valid objection if you have an examination that either inserts facts that haven't been established yet, or you haven't, by agreement, agreed to those facts as of yet.
But I'm talking about cross-examining. I'm not saying it's not at times, but if I'm cross-examining someone and I say, you know, is Ms. Jones outside? Something that may not be perfect, but or Ms. Porter outside. Keith Adams said that, the Honorable Keith Adams. And the objection, I believe, was sustained to facts not in evidence. And if I'm wrong, I'm just giving an example there. On a cross-examination, the questioner, that's the whole point, can ask about things that were not in evidence. They have to, of course, have some sort of good faith belief, but they can ponder those questions. No one has to have it in evidence. Otherwise, we are tied to the federal rule of only things that came out on direct.
No, because Georgia doesn't have a scope rule. So I'll consider it on a case-by-case basis, but.
Okay. Well, thank you. That was it.
All right.
Thank you, sir.
Okay. All right, Sergeant Ingram, go ahead and summon our jurors, please. All right, thank you, Sergeant Ingram. Ladies and gentlemen, please be seated. All right, ladies and gentlemen of the jury, good morning. Good morning. All right. Without further delay, we're going to go ahead and continue with the presentation of the state's case. All right, counsel, call your next witness.
Good morning, Your Honor. The state at this time calls Gregory Piper to the stand.
All right, summon Gregory Pfeiffer, please. Mr. Pfeiffer, good morning, sir. You please go ahead and face Sergeant Ingram and be sworn as a witness, please.
Yes, sir. Yes, sir. My name is Gregory Pfeiffer, Gregory Peiffer.
Good morning, Mr. Piper.
Good morning.
What is your current occupation?
I'm currently a forensic biologist.
And where are you employed in that capacity?
I am employed at the Bureau of Alcohol, Tobacco, Firearms, and Explosives, commonly known as the ATF.
What is, and what are your duties at the ATF?
My duties at the ATF are to be a forensic biologist, which means to process evidence as it relates to ATF incidents, to analyze evidence for DNA, to generate reports, and to testify in court.
And have you worked in any other capacity prior to your employment with the ATF?
Prior to my employment with the ATF, between 2012 and 2015, I was employed by the Georgia Bureau of Investigation, Department of Forensic Sciences, commonly known as the State Crime Lab.
And what was your official title or role there?
My title at the GBI was also as a forensic biologist.
And what were your duties or responsibilities at the GBI as a forensic biologist?
Similar to those of the ATF as a forensic biologist, the duties are the same. So my duties at the Georgia Bureau of Investigation were to process evidence from state and local agencies that was submitted to the GBI Crime Lab, process that evidence for biological material, analyze biological material for the presence of DNA profiles, generate reports, and testify in court.
And can you tell the jury what your educational background is?
I received a Bachelor's of Science in the specialty of genetics from Iowa State University in 2004. I am not finished, sir. and then in 2012, I received a Doctor of Philosophy, also in genetics. At that same time, I also received a graduate certificate in forensic sciences. I am now done.
There we go.
Yes, sir.
And were you required to undergo any specialized training to become a forensic biologist?
To be a forensic biologist, the specialized training really comes in on-the-job training. So at the Georgia Bureau of Investigation, I underwent a many-month training program that included oral lectures, written examinations, proctored examinations with evidence, supervised casework that ultimately culminated in a mock court. I then, once I joined the ATF, underwent that same training program, but as oversaw by the ATF at that time. So that would be my specialized training in forensic biology.
And Mr. Piper, do you belong to any professional organizations?
I belong to the American Academy of Forensic Sciences as a member of that organization.
And how long have you been a part of that organization?
And how are the numbers looking? We're landing at a strong 70. Ooh, SPF.
Thanks to JetBlue's low fares, Kayla's in vacation mode already.
Nuestro viaje comienza en la tierra de los sueños, donde las oportunidades florecen llenas de esperanza. Las primeras generaciones de inmigrantes cruzaron océanos, fronteras y muchas barreras. Ellos trabajaron sin descanso. Su sudor alimentó el suelo de esta gran nación.
Their sacrifice was our foundation.
Now their children stand tall, ready to honor that legacy.
Hoy depositamos nuestros votos, no solo por nosotros, sino por todos aquellos que no pueden hacerlo. Hoy votamos para definir nuestro destino, para proteger los sueños de las generaciones pasadas y de las del futuro.
Unámonos, hagamos que nuestras voces sean escuchadas.
We build bridges and break barriers and forge a brighter tomorrow together.
Hoy nosotros votamos por aquellos que no pueden.
To my recollection, it would have been around 2014 to current.
And is there a certification process to become a forensic biologist with the GBI?
There is a certification process, but that is not a requirement to be a forensic biologist. There's actually a small subset of forensic biologists that are certified. There's a certifying body, the American Board of Criminalistics. I hold with that body a certification in molecular biology, which is under the umbrella of forensic DNA analysis. And I am current and open with that certification.
Okay. And have you been previously qualified to testify as a forensic biologist and DNA examiner?
In court?
Yes.
Yes.
And about how many times?
I believe this will be my 16th testimony, plus or minus one.
So I want to ask you, what is forensic biology?
Forensic biology is the science of analyzing evidence for the presence of biological material, looking for the presence of blood, semen, saliva, analyzing that evidence to generate DNA profiles that can be used to compare to known DNA profiles submitted from individuals to make associations to the evidence.
What is DNA?
What is DNA? DNA stands for deoxyribonucleic acid. It's the A's, C's, T's, and G's that you learned back in school. It's the basic building block of all life. You receive half of your DNA from your mother and half your DNA from your father. It is set at conception. It remains the same throughout your life and throughout various cells of your body. So we can use DNA from the inside of your mouth to compare to blood or DNA from the surface of your hands. It is unique to an individual. So with the exception of identical siblings, be that twins, triplets, etc. But it's unique to an individual and can be used to draw associations of known DNA standards to evidence samples.
And how is DNA deposited on items?
DNA can be deposited on an item from any number of ways. As mentioned earlier, what DNA is, blood, semen, and saliva all contain DNA. And so if any of those substances are deposited onto an item of evidence, there may be DNA there. However, there's also something called touch DNA. And so I see, sir, that you have a water bottle on the floor. Sorry, I talked directly to the jury, but as if somebody were to pick up that bottle and touch it, you would deposit DNA from the surface of your hand to that item, and that would be DNA that I could analyze as a forensic biologist.
Let's expound upon that. How can DNA be collected from items of evidence?
DNA collection process starts with an evaluation, and I look at evidence to try to determine where DNA may be deposited on an item. The actual collection of that is I use something similar to a Q-tip, commonly used to clean things around the house or on your physical person. We have sterile cotton swabs that we use to collect DNA. The standard process would be, once I identify an area to swab, moisten that swab with liquid, a sterile water, use that sterile wet swab to swab the evidence, to collect any biological material from the evidence onto the swab. I then follow that back up with a dry swab, similar to mopping the floor. If you use your wet mop, you still need to go back and clean it again. So we're trying to get all of the biological material off of an item of evidence and onto cotton swabs that I can then use in my DNA analysis process pipeline.
Okay, and after you've performed that collection process, what else, if anything, do you do after that?
Sure. The DNA collection process is just the first step of DNA analysis. We need to obtain DNA from the evidence and move that to our DNA analysis pipeline. The pipeline can be thought of as 5 basic steps. First step is DNA extraction. So we would cut the swabs that I took from the evidence and put that into a tube and add chemicals to break apart the cellular material that's there, to wash away any substances from the evidence itself. And so we end up with a purified sample with DNA in it. The next step is then to figure out how much DNA I had. I don't know at this point in time if I obtained any DNA from an evidence sample. So I use my quantitation step to determine whether or not any DNA is present on my evidence. After that, I use that information in the next step to use something similar to like a molecular Xerox machine. So something if you were making photocopies of a piece of paper, you would put it in and make hundreds to millions of copies of that piece of paper. I do that using instrumentation and chemicals in the laboratory to amplify and generate multiple copies of the small amount of DNA I obtained from the evidence. After that, I use sensitive instrumentation to detect the DNA sample that I just processed and amplified. The final step in my DNA analysis process is looking at the data that comes off of my sensitive instrumentation to determine whether or not a DNA profile is suitable for comparison.
Okay. So I would like to ask you, what is a DNA profile?
A DNA profile is a collection of data as it pertains to somebody's DNA. And so if we think of a DNA profile as a collection of data from particular locations throughout your DNA. And in the testing that I normally do, we would look at anywhere from 15 locations of the DNA. And each one of those locations would give me information. And so if we look at it graphically, it's much like every other graph. It's an X with a Y axis where size is on the X axis going across, and how tall the peak is how much information is present. At each one of the locations of DNA that I look at, if we go back to the definition of DNA, you get half from your mother and half from your father. I can expect 2 pieces of information, one from each individual that donated DNA to your life. And sometimes those are separate and sometimes they're stacked if the same information came across from both parents. And so that collection of data, the number of peaks, the size of the peaks, is the information that I put together to build the DNA profile.
Okay, what is DNA comparison?
DNA comparison. As I generate DNA profiles from evidence, that can only do so much. To be able to associate that or include or exclude any particular individuals from that evidence, we need to have a known standard from an individual. I would run the known standard similar to the rest of my standard DNA testing. I would generate a DNA profile from the known standard. And then once I have all of that information for those 2 DNA profiles, it's as simple as looking at one, looking at the other, and determining whether or not there's a match or if they're the same. So if we think of the simplest option, a single source DNA profile to a known standard, I would expect that they would give me the same DNA information at each location that I would see in the DNA profile.
And when you say a known standard, what do you mean by that?
So known standards typically come in as something called a buccal swab, which is a fancy word to say just the cells on the inside of your mouth. So as known standards are collected, it's usually that same cotton swab that I use to collect from the evidence, but is used on the inside of an individual's mouth, packaged and sent into the laboratory, saying that these samples came from this individual.
And what are the potential outcomes of DNA comparison once you finish your analysis?
So as I make comparisons, the basic determination is whether or not there's a possibility that somebody is included in the evidence, meaning the DNA types match, that they're similar across, or that a person is excluded, meaning that there's at least one difference in the DNA, that they're not included as a particular sample. So inclusion and exclusion with the level of testing here.
What are the quality standards, if any, for DNA examination?
There are various accrediting bodies for crime laboratories, such as the American Society of Crime Laboratory Directors Laboratory Accreditation Board, or ASCLD Lab, who then audit a laboratory to a certain set of standards, the International Organization Standards 17025, for example, which is what the accreditation standard for the Georgia Bureau of Investigation was when I was there. There's also another set of quality standards. These are written and published by the Federal Bureau of Investigation, and they're known as the Quality Assurance Standards, or QAS. It is also a series of requirement documents that a laboratory must meet and then are audited to on a regular schedule.
Have you had the opportunity to personally perform DNA analysis?
I have.
And how do you determine whether a known DNA profile is consistent with a known sample profile?
So as stated previously, it can be as simple as looking at a known DNA standard and comparing that to an evidence sample. So if we take just one location of DNA and I see that there's a 910 at this location and the reference standard is also a 910, at that, there's an inclusion at that location. And then I do that for each location throughout the DNA profile. So up to 15 locations. And if they match it every single one of those, then every single one of those that is used in comparison then is a match.
And how do you determine whether a DNA profile and a known sample are suitable for comparison?
We built our band's website with Hostinger AI website builder.
Meet the easy way to succeed online. Just describe what you need in the prompt box and let AI create your website in no time at all.
What's cool is that we get to just like keep building it, and it's super easy to like change things around.
It's wicked simple, and it's all drag and drop. All of our merch is all things that I just drew. We can actually sell them on our website.
Whatever you do, it's better with a website. Hostinger. 3, 2, online.
These mushrooms make you feel better. They increase focus and energy while keeping you calm and stress-free. Plus, they cut down on bloat and heal your gut. Wait, and they taste good? Someone should make a coffee out of this stuff. Rise. Feel better.
Start with known samples. Determine whether or not a known sample is suitable for comparison. It needs to meet the expectation. Known samples should be a single source DNA profile. If I receive a known sample and there's indication there's 2 or 3 people involved in that sample, I'm not going to use it any further. I'm going to make that not suitable for comparison because it is not a single person as expected. Looking at evidence samples to determine whether or not an evidence sample is suitable for comparison. And there's a list of protocols within the laboratory as governed by the 2 accrediting bodies that we previously discussed. As long as the DNA profile meets the requirements of the laboratory, if we're able to determine the number of contributors that are contributing DNA to the sample, if we're able to use our interpretation protocols, our flow charts, if they are flow charts, to determine whether or not you can pull a major contributor or pull one sample out from a larger mixture component. That, through training and experience and the laboratory's protocols, is how you end up determining whether or not a sample is suitable for comparison.
And are the procedures and analysis that you have given the jury understanding of something that is generally accepted within the scientific community?
They are.
And are the procedures that you describe reliable and reproducible?
They are.
And did you follow these procedures for the case that you're currently here to testify on?
I did.
Right. At this time, the state now moves to qualify Mr. Gregory Piper as an expert in fields of forensic biology and DNA examination based upon his background, training, and experience. As so testified.
No objection on behalf of Mr. Williams, sir.
Anybody else wish to blot out the witness? Okay. The court will designate Mr. Pfeiffer as an expert in the area of forensic biology and DNA testing.
Okay. Mr. Piper, during your employment with the GBI, were you required to produce reports?
Yes, there's a standard practice of my position is to analyze evidence and issue reports to that analysis.
And did you prepare one for this case that you're here to talk about today?
Yes, sir.
I am now showing defense what has been previously provided. It states exhibits 143 Charlie, states 143 Charlie Alpha.
Yeah, the new one. Be so stupid. Okay.
Now approaching the witness, Your Honor, with your permission, the state's exhibits 143 Charlie and 143 Charlie Alpha.
You may, sir.
Thank you. Mr. Piper, starting with stage 143 Charlie, what have I just handed you?
This is the Georgia Bureau of Investigation, Department of Forensic Sciences official report to the analysis that I performed in this case.
And how do you know what it is?
Well, I can see the header of the report that has the DOFS case number listed at the top, including my name, title, and signature at the end of the report.
What is stage 143 Charlie Alpha?
This document, 143 Charlie Alpha, is the Department of Forensic Sciences STR frequency report. In more simpler terms, this is the document that supports the statistical conclusion made and supported in this report.
And how do you know that what is stage 143 Charlie Alpha?
I recognize it again by the header of the report, a note by our laboratory information management system that it was inserted into the record by myself on April 2nd, 2014, and that the analyst of record on the document is Gregory Pfeiffer, which again is me.
And has either exhibit stage 143 Charlie or 143 Charlie Alpha been altered in any way?
This is the beginning of the rest of your lives. When you encounter adversity in life, nothing can ever take away the education and degree that you have achieved. It is yours to own and keep. Every challenge you have faced over these last few years has transformed you into the accomplished individual you are today. Those of you walking the stage are a different version of yourselves today than the day that you signed up for school. Education empowers people to overcome barriers, to break the cycle of poverty, and to build a life of dignity and opportunity. It is the foundation upon which self-sufficiency, confidence, and leadership are born. Education is the very bedrock upon which transformation is built. You have within you the power to be a force for change. Embrace that power with conviction, shape the future with your dreams, your actions, and your unwavering commitment to making the world a better place. The world is waiting for the transformation that only you can bring.
We've never seen a force like this.
The state's exhibit number has been added to both documents.
Your Honor, at this time, but other
Near the top of the report.
ASCLAB Lab International Accredited is on the report.
ASCLAD Lab. This is in the middle, right next to the barcode. This is the American Society of Crime Laboratory Directors Laboratory Accreditation Board. This is the accreditation board that I referred to earlier as far as quality standards for a testing laboratory. It is just noting that in 2014, the Georgia Bureau of Investigation adhered to these standards.
Based on your report, did the GBI crime lab receive any evidence pertinent to this case? You can scroll down.
Is this a touch screen?
Oh, actually, it's controlled from here.
Okay. So standard on these laboratory reports, near the top of the report, there's a section called evidence. This lists the evidence that the laboratory received from the state or local agency to test for forensic means. And in this case are the samples that I tested in this case.
And what did if you would itemize and go line by line, what you received from this, in this case?
Line by line, yeah. So for clarity's sake, I'm going to start at the second main bullet on the evidence that was received on October 24th, 2013 from the Atlanta Police Department via lockbox. Evidence that comes into the laboratory comes in through a lockbox. Once it is in the lockbox, it is then accessible to the laboratory employees. The evidence that was received is a sealed package containing evidence for forensic examination. Once it was in the laboratory, it was then sub-exhibited. So Exhibit 3 is a package of evidence from the agency. Item 3A, as noted on this report, was sub-designated from other evidence, and it is a Ruger 9mm firearm bearing the serial number listed here on the report, 302-44238. The next item of evidence is item 4. It is again a package containing evidence for forensic examination. The exact items are exact forensic known samples. These are identified as items 6, 7, and 8. Item 6 are buckle swabs from one Frederick Prothrow. Item 7, buckle swabs from a Walter Murphy. Item 8 are buckle swabs from an Adrian Bean. So that was the evidence that the laboratory received from the Atlanta Police Department. The top of the evidence list, to reference that, so we can go back, these are items of evidence, as noted on the report, that were created by myself, Gregory A. Pfeiffer. They are exhibits 11 through 15. Exhibits 11 and 12 are swabs that were collected from items 4A and 5A, respectively. They are swabs of potential stain that were identified on the firearm that were outside of the requested examination, saved for future possible testing. Exhibits 13, 14, and 15 are saved DNA product, DNA extract. So I had more DNA that I needed for my testing. So we retained this within the laboratory. They are 13, 14, and 15 from items 3A, 4A, and 5A, respectively.
If you're sitting around Googling how to make money on the internet and your ass is tired of being broke, let me tell you what your parents didn't tell you.
I want to go back to a few things that you spoke about earlier during your response. When you say sub-designated, what does that mean?
Great question. So if we receive evidence that has multiple components inside of a single box, for instance, if there was evidence that came in that had a firearm, an ammunition magazine, as well as intact ammunition cartridges, it is easier for tracking throughout the laboratory and denoting where samples came from to sub-designate that evidence using letters in this instance. So 3A, for example, the firearm became 3A, and it is beyond my recollection for the ammunition magazine and the ammunition cartridges on what those are designated, but we can speak directly to a subset of the evidence by sub-designating these numbers.
And earlier you talked about a lockbox. Can you tell the jury why evidence was arrived in a lockbox?
Yeah. So quite often when state and local agencies need to deliver evidence to the state crime lab, there needs to be a secure chain of custody from the submitter to the laboratory. There needs to be an interaction between those two entities. To facilitate that, you would need in-person interaction or a secure means of transfer. The secure means of transfer is what was used at the Georgia Bureau of Investigation via a lockbox. The agency, submitting agency, can show up at the crime lab, access through a secure door, access a secure locker, submit the evidence to the laboratory, make the request for what forensic examinations they need to do, place it into that lockbox. Once it is closed, it is only then accessible to the laboratory. That maintains that chain of custody that they put it in and the only people that can get it out are the crime lab. We then, once we get the evidence, enter it into evidence within a case number. In this case, we've discussed the case number.
Earlier you described that you received this the evidence that you test here from the Atlanta Police Department. And based on your report, from who requested testing of this evidence that you analyzed?
Referencing the report, it is a D. Quinn that requested this examination.
Are there case subjects associated with this report?
Referencing the report, there are 4 individuals listed in the case individual section. 3 of them are denoted as subjects: an Adrian Dean, Frederick Prothro, a Walter Murphy, and then there's 1 designated as victim, E. Robeson-EL.
Earlier you stated that, and if you will scroll down just ever so sorry, thank you, right there. Earlier you stated that you created certain evidence numbers or evidence within this report that is referenced. Can you tell the jury why that was?
So any product of my examination needs to be tracked for a chain of custody. Just like all evidence, we need to maintain the chain of custody to provide integrity. In this case, the DNA extracts that I generated, again, I did my 5-6 step process: DNA collection, extraction through profile development. If I didn't use all of the DNA, if I didn't consume the sample to generate my DNA profile, I have evidence left over at that point. I have extracted DNA that could be saved for potential retesting in the future. With that, I then create within our laboratory information management system an item of evidence, a tracking number for that evidence. Same goes for exhibits 11 and 12, the swabbing of those 2 stains on items 4A and 5A. I took swabs that I did not use in my testing, and those need to be tracked throughout our system for potential use at a later time. That's why those were all entered as new evidence or created by me through my testing process.
And is that something that you would routinely do throughout your time at the GBI if the occasion should arise?
Yes. Anytime that I create something or I generate some sort of continuing evidence, I create a number for it and enter it into our laboratory information management system.
Just a brief indulgence, Your And Mr. Piper, I'm going to direct you to your left, where there are some gloves right behind you. And would ask that if you would retrieve 2 for yourself and 2 for me.
Let's go, people. Excellent.
Y'all, here's some news that'll put some money in everyone's pocket. Every American is able to pocket these spending cards that are loaded with 5,800.
I believe, yes.
147 Charlie, 148 Charlie, 144 Charlie, 145 Charlie, 146 Charlie.
Yes, correct. So the duplicate 144 Charlie will become 149 Charlie. And that, which is, yes, sorry. No, get some more. Disinfectant. Yes, that's perfect. It's gonna be. Yes.
I saw you, I heard you.
All right, I am now approaching you, Mr. Piper, with state's exhibits 147 Charlie, 148 Charlie, 149 Charlie, 146 Charlie, and 145 Charlie. Can you take a moment to review what I have just handed you and look up at me after you have done so? Okay, what have I handed you in form of state's exhibits 145 Charlie to 149 Charlie?
Sure. 3 of these, 145 Charlie, 146 Charlie, and 149 Charlie, are the known reference samples that are listed in my report as items 6, 7, and 8. I recognize them by the DOFS case number on the sticker, as well as, hard to see, but across the evidence tape, as I resealed the evidence after testing, my initials, GAP, just like the store, and the date, along with the evidence sticker that includes the known reference sample names. These two, which are 147 Charlie and 148 Charlie, are the 2 exhibits that are listed at the top of the report. So DOFS numbers 11 and 12, which are swabs of stains from items 4A and 5A. Recognize these by my handwriting listing out the DOFS case number, a description written on the package, date, my initials, as well as for sealing purposes, my initials across the tape, and none of these look to have been open since I last closed them.
Your Honor, at this time, the state now moves based on the testimony to admit state's exhibits 145 Charlie, 149 Charlie into evidence at this time.
Any objection to states 145 through 149 Charlie?
Yes, Your Honor.
Basis.
There's no foundation, but the prosecutor promised me they call Officer Henton, so I'm okay with letting it in with that condition. That's what the prosecutor told me. Correctly, I vote.
All right, I'll overrule your objection at this point in time, subject to your agreement. Okay. So stage 145 through 149 are admitted, maybe published as usual.
All right, Mr. I handed you some scissors. You can start with stage 145, Charlie, and open it with the scissors.
So at this point, for clarity, I apologize to ask for clarity. To open this, I do not know what is inside of this. For evidence integrity, I don't have a clean surface. I'm not wearing proper PPE. So I will open, just want to open it with that understanding.
Yes, please open.
Yes, sir.
What if your smile could go from looking like this to this? Would you be more confident? Would you laugh a little?
There is one more envelope inside
Yes.
of that envelope.
And if you would just be as kind as just open it and look inside without putting it on the top of the witness, and it would be appreciated.
Would you like me to remove the evidence?
You can just look inside and tell the jury what you see inside.
Yes. So inside this package, there are cotton swabs similar to the Q-tips we discussed earlier. They're wooden sticked with a cotton flocked end. And these are the buccal samples from identified as Walter Murphy.
All right, let's transition to state's exhibit number 46, Charlie. Would you do with stage 146, Charlie, as you've done with stage 145?
Yes, sir. The evidence inside this package is the same. They're wooden sticked cotton swabs. Quantity appears to be 4. Cannot confirm based on taking it out, but it is evidence tape sealed, my initials and date, listed as from Adrian Bean.
All right, would you do and replace that, please? Would you do with stage 147, Charlie?
147, Charlie?
Yes, sir. For the next.
The next reference sample?
Yes.
That would be listed as 149, Charlie. Guess the wrong end. This evidence also contains swab wrappers containing the swab sticks, again, wooden stick, cotton end, identified as Frederick Prothrow.
And as with stage 149, Charlie, when you do the same with 147, Charlie, I understand you will.
I have never done this, but I would recommend against opening this on the stand as it will compromise the integrity of the evidence for future testing.
Your Honor, I believe we could open the evidence and present it as such, provided the court has no objection.
Well, he's telling me he recommends you not open it. so I'm gonna follow his direction, okay? So,
And I'm gonna follow you.
okay, all right, so,
All right, I'm gonna reclaim these exhibits from you.
That works.
All right.
let me ask you something. Can you open it up in a controlled, or in another space and let everybody look at it?
I could, if you provide me some bleach, a mask, a lab coat, brand new gloves, proper PPE, or either in the court or outside, I would be happy to open it.
Okay, all right.
We're gonna follow your instructions.
I think we'll defer for the time. Okay.
All right. And I am now going to approach with states, with the assistance of Deputy Ingram, State Exhibit 114, Charlie. But prior to doing so, Your Honor, I am going to allow defense counsel to see states 114, Charlie. One 14, Charlie. I'm not seeing him looking again through. Yeah, so I'm doing substance. Okay. All three at one time. Okay, I am going to show defense counsel to all the state. I'm going to show you what has been previously marked as state exhibit 115, Charlie.
If you're looking for a career where you can really make a difference in the world, to help and connect with others in a meaningful way, and want to learn how you could become the best version of yourself, then this message is for you. In short, I've set a goal for myself to help change the lives of 1 billion people around the world, but I can't do it alone. I'm looking for someone who is genuinely willing to learn and grow and wants to help others do the same. If that sounds like you, then I want to show you how you could turn your passion for helping and empowering others into a rewarding new career that's about more than just paying bills, but really making a difference in the lives of the people in your community and around the world. So if you've ever felt called to coach and guide others, if you're passionate about helping and empowering the people around you, and you've got a burning desire to become something more, a real force for change and the good in the world, then please click the link below this video now and join me on this life-changing mission.
And I am now going to show defense counsel the previously marked as well as states 116, Charlie. Starting with state exhibit 114, Charlie. Thanks, sir. Can you take a moment to review that and then tell me what you are looking at that I just handed?
This item contained in this box, 114 Charlie, is DOFS item number 3 in its entirety, which contains 3A. I recognize this based on the DOFS case number written on the sticker, my initials and date across the evidence tape on the box.
Okay.
Bless you.
I am now going to reclaim from you states 114 Charlie. We'll show you whether it's been also pre-marked as states 115 Charlie, which has already been shown to defense counsel. And with the last exhibit, would you please open that exhibit and tell me what it is that I know? And what have I just handed you, Mr. Piper?
This exhibit 115 Charlie is DOFS case number or item number 4, which contains item 4A.
What is item 4A?
Item 4A is one Taurus 9mm pistol bearing the serial number TCX 63132.
Okay. I'm going to reclaim from you states 115 Charlie, and I'm going to give you again states 114 Charlie. Can you tell me, or tell the jury, excuse me, what is contained? What is the item that is contained? 114 Charlie.
Yes. It is not evidence.
Is there an objection, Mr. Steele? What's your objection?
It is not an evidence yet.
I sustain the objection. You can just lay a little more foundation, okay?
What is contained in states 114 Charlie?
I'll overrule that, okay?
And it's the same premise.
I'll overrule the objections, okay? Because he's got to identify he's got to be able to identify the item, okay?
You may answer the question.
114 Charlie contains one Ruger 9mm pistol bearing the serial number 302-44238, along with the rest of item 3.
And does the box that I've handed you also contain a serial number that pertains to your report?
This box has the DOFS case number on the DOFS case sticker, as well as my initials and date that I sealed the box.
And as I'll ask you a question, is 114 Charlie, which I reclaimed from you, also one of the items that you tested, took a sample from?
I took a sample from 114 Charlie.
Did you also take a sample from states 115 Charlie?
This is item 114 Charlie.
115 Charlie, right?
Yes, I did also sample from 115 Charlie, which was discussed earlier as the Taurus 9mm pistol.
All right. And I am now going to show you what has been previously marked as states 116 Charlie. And as with the prior exhibit, I'm going to ask you to look in, and after you've done so, you will say therein, look up at me and tell me what's in it.
Latina Power fuels our democracy. Exigimos respeto por nuestros cuerpos y por nuestras vidas. Everyone knows it. Women's reproductive rights are fundamental to democracy in a free country. Georgia es nuestro hogar. Nuestro voto puede redefinir políticas que le dan forma a esta nación. We're not just voters. We're architects of change. Vote. Vota. Because her right to choose matters.
.116 Charlie contains DOFS item number 5, which is one Taurus 40 caliber pistol bearing the serial number SAN 09791.
And is that exhibit that you have in front of you also an item that you took a swap from at the time you performed your analysis for this case?
This is an item that I sampled from for this case.
Just a brief indulgence.
Yes, sir.
Okay. Did that conclude your involvement in this case?
The DNA testing of this evidence concludes the involvement with this case.
Brief indulgence.
Yes, sir.
At this time, Your Honor, the state now moves to admitting the evidence states 114 Charlie, 115 Charlie, 116 Charlie.
Any objection to states 114, 115, or 116 Charlie?
Your Honor, based upon our previous agreement, I want to check so if it's not moved up.
You can renew your objection at that time. Okay, all right, that's fine. All right, states 114 Charlie, 115 Charlie, and 116 Charlie are admitted subject to additional foundation.
All right.
And maybe publish to jury as you see fit.
Thank you, Your Honor. With respect to your report, the analysis that you concluded, can you tell the jury what your conclusions were with respect to your test?
Yeah. Would you like me to go through the whole testing and response item by item? With this testing, we sampled the grips, the textured areas of the grips, and the trigger from each of the three firearms discussed earlier. DFS items 3A, 4A, and 5A. Grouping them for clarity, the DNA profiles obtained from 3A and 5A were not suitable for comparison. They were both at least 3 individuals contributing to that DNA profile and were not suitable for comparison. The DNA profile obtained from item 4A was also from at least 3 individuals, as noted in the report. And we were able to identify a major contributor that was suitable for comparison in that profile. Within the report, this is identified as the first DNA profile. It is a profile that is suitable for comparison. The other components of that, persons 2 and 3, were not suitable for comparison, so we didn't draw any conclusions or any comparisons to those components. There was a comparison made to the major DNA profile from item 4A. We compared that DNA profile to the known standards from Frederick Prothero, from Walter Murphy, and to Adrian Bean. The comparison showed that Walter Murphy was a possible contributor to the major component DNA profile obtained from item 4A. The other 2 individuals were excluded as possible contributors to this profile. So that means that Frederick Prothero and Adrian Bean were excluded as contributors to the major component of item 4A. The weight of that association, or the statistical number that accompanies that statement that Walter Murphy was included as a possible contributor, is this. Assuming the major component is a single contributor, the probability of randomly selecting an unrelated individual within the population is 1 in 5 trillion Caucasians and 1 in 230 billion African Americans.
Earlier, you stated just a few moments ago that they were not, results that you got were not suitable for comparison, to use your words. Can you tell the jury what you mean by that?
Sure. A profile is either suitable for comparison or not suitable for comparison based on the laboratory's protocols, and the analyst training and experience. For example, if there's to that profile, if
the Beast Clipper Pro gives you everything you need for both straight and tapered styles. And the extra sharp cutting blades give you the perfect barbershop haircut in minutes. So do it yourself without it looking like you did it yourself with the Beast Clipper by Skull Shaver.
We built our band's website with Hostinger AI website builder.
Meet the easy way to succeed online. Just describe what you need in the prompt box and let AI create your website in no time at all.
What's cool is that we get to just like keep building it, and it's super easy to like change things around.
It's wicked simple, and it's all drag and drop. All of our merch is all things that I just drew. We can actually sell them on our website.
Whatever you do, it's better with a website. Hostinger. 3, 2, online.
if there isn't enough information within a DNA profile to draw conclusions, that profile is also not suitable for comparison. And so in this case, with items 3A, the DNA profiles obtained from items 3A and 5A were not suitable for comparison based on the laboratory's protocols and my training and experience at that time.
Was there, and in the process of your analysis, was there something that was suitable for comparison?
Yes, the major component from item 4A was suitable for comparison based on the laboratory's protocols at that time.
Okay, and what was the result of that comparison analysis?
The result of that comparison is that we compared the DNA profile obtained from the major component of 4A to the 3 known individuals submitted in this case. Frederick Prothro and Adrian Bean were excluded as possible contributors to that major component. Walter Murphy was included as a possible contributor to that major component, given the statistics stated earlier.
How are you able to say that there were 3 contributors to the mixtures on the submissions of 3A and 5?
Based on the information that we have of how DNA works, we get half from our mother and half from our father. And if we remember, there are locations of DNA. The DNA you obtain from your mom, the DNA you obtain from your dad are both going to show up at each location. And so at each location of DNA, I have an expectation for a single individual that at most I'm going to see 2 peaks, right? One from mom, one from dad. As more individuals contribute to a DNA sample, I'm going to see more peaks. If I see 4, expectation of 2 individuals. If I see 6, expectations of 3, continues on with that level. Knowing that it isn't always that simple because there could be stacking of similar DNA types between individuals or within the same individual if you receive the same DNA type from your mother and your father. But that is part of the protocols and the training experience to be able to interpret the DNA profile. But looking at the number of peaks and the relation of the peaks in those DNA profiles, we were able to determine that it was at least 3 individuals contributing to those samples.
And Mr. Pfeiffer, did that conclude your involvement with this case?
Yes, sir.
At this time, Your Honor, I am reclaiming State's Exhibits 116 and the state now refers to the defense for cross-examination.
Okay. Ladies and gentlemen, we want to take a comfort break first? Okay, all right. Counselors, and jurors, we're going to be in recess for about maybe 5-10 minutes to allow everybody to take comfort. We'll come back, okay? All right. All rise. All right, jury is left. This Mr. Pfeiffer, you can take 10 minutes. Just come back, okay? All right, we're in recess for 10 minutes.
wants to pull another all-nighter? Who's gonna review a ton of evidence? You? No! Cecilia is. Behold, Disco's new AI assistant. Here it hum. This weekend, have a weekend!
Our roots stretch across continents. Our hearts beat in rhythm with the land. We are the stewards of this earth. All of us feel the weight of environmental issues. Pollution, global warming, deep in our souls. Georgia, our home, present and future for next generations. It's time to act against climate change. We've seen the storms and felt the heat. Many families have moved in, seeking security. We have the opportunity to change that reality. Vote because our future depends on it, and our choices shape the world.
Election alert. Election day is on November 5th. Who you vote for is private, but if you vote is public information. After this election, your voting record will be updated, and your friends and family will be able to look up how often you vote. So vote on or by Tuesday, November 5th.
Think you know Mitsubishi? Think again. Today's Mitsubishi is more reliable than Hyundai, Toyota, even Honda, according to J.D. Power. And when you think a new standard of satisfaction, think Hutchinson Mitsubishi. Save on nearly 300 new Mitsubishis and pre-owned vehicles without the pressure. Hutchinson has the perfect car for everybody and every budget. Plus, get the Hutchinson Advantage, our lifetime limited warranty. So when you think quality, value, and a new standard in satisfaction, think Hutchinson Mitsubishi on Margie Drive in Warner Robins.
I'll do it first. All right, thank you, Sergeant Ingram. Ladies and gentlemen, please be seated. All right, Cross.
Good morning, doctor. I just have a couple of questions for you, if I may. You're given, in essence, 3 firearms and the items that came with the firearms that you looked at and identified here today. Is that fair to say?
That is correct.
And on 2 of the firearms, there was not enough DNA to test to determine who was a major contributor. Is that a fair analysis of what you told us?
That is an explanation. However, I would expand upon that and say, in these instances, there's almost too much DNA to test, given that the numbers of contributors that were in these samples were higher than the complexity in which I could evaluate the sample. So it wasn't too little information, it was the complexity of the profile.
And then the one firearm that you were able to have a major contributor, just tell ladies and gentlemen, jury, which firearm that was.
That was the firearm from item 4A to reference the report. So the correct firearm is the Taurus 9mm pistol.
And then you have major contributors and not major contributors. Is that a fair way to say it?
The major contributor and the non-suitable minor components.
And the major contributor you said is, to a scientific degree that you specified already, is a gentleman you're calling Mr. Walter Murphy. Fair to say?
There is evidence to include Walter Murphy as a possible contributor to the major component from that DNA profile, given the scientific weight stated earlier.
Now, you also mentioned that a gentleman, Mr. Prethro, remember that name?
Yes.
And he was excluded from the major component of that DNA. Is that fair to say?
Yes, from the component of the profile that we made comparisons to, he was excluded from that component.
And the same question and then same answer, I believe, for the person named Mr. Bean. Fair.
I'll stand in objection, Mr. Form. You can rephrase it, Mr.
Okay. It's going to be the same question. As to Mr. Bean, remember that name?
Yes, sir.
Adrian Bean. That person, DNA, the known sample, was excluded from the major contributor on that item. Is that fair to say?
Yes, from the component of the mixture that I was able to draw comparisons to, Mr. Adrian Bean was also excluded.
Does not mean that Mr. Bean was not on that firearm, but we're talking about the major component. True?
That is correct. No assumptions or comparisons were made to the additional contributors beyond, as the report identifies, I think it's
Mr. Murphy.
First profile of the major component.
Mr. Murphy.
The sample that is associated with Mr. Murphy.
I want to thank you, Doctor. Your Honor, thank you so much.
All right, any further examination?
No, Your Honor.
Not you yet. Okay. All right, Mr. Matthews.
Mr. Pfeiffer, good morning, sir.
Good morning, sir.
I just have a few questions. You talked about touch DNA. With respect to touch DNA, can you explain to the jury what exactly is the DNA material or life material that is in the hand that is transferred to items?
Yeah. So touch DNA is sort of a catch-all for biological material in which we haven't otherwise characterized. So we have serology tests for serology meaning bodily fluids for blood and semen and saliva to determine those types. Touch DNA is a category for oftentimes a low-level DNA that we don't have otherwise characterized. Most often when touch DNA is used as a term, it truly means because something was touched. And so to answer specifically the question, what is it? Where's the DNA come from when we talk about touch DNA? So throughout the day, your epithelial cells, which is a scientific word for the cells that make up the skin or your hand, those end up falling off or being pulled off. So if you think of, like, if you're sandpapering an item and you end up sandpapering your hand, you can feel a little bit of your skin actually come off. So those would be the cells that we're looking at. But that's a natural process throughout the day depending on how long it is from the time in which you wash your hands and the time you touch something, you may have a different amount of DNA that's left behind. But not only the DNA contained within cells is present in touch DNA. Sometimes there's non-cellular DNA or cell-free DNA that's the cell's already been lysed and there's just DNA on your hand. Or you may have touched something else and picked up that DNA from touch.
Is it possible to leave the cell from the hand on a door handle of an automobile?
Yes, it is. Anything that we touch, anything we come in contact throughout the entire day, your cell phone, the door, the railings, all have the potential for leaving touch DNA behind.
How about a cell phone?
Yes.
How about a ring?
I believe you said a ring?
A ring.
Yes, I would actually expect quite a high level of DNA on the ring that I'm currently wearing.
About, I think you testified earlier about a handgun, correct?
Yes. Handguns are something that you would touch.
How about how about a jacket?
Yes.
Where would the cellular evidence be transferred if you were wearing a jacket?
So we talked specifically about touch DNA from your hand, but the entire human body is covered in epithelium. Your entire body is covered in skin. And so when we talk about skin or epithelial cells, touch DNA cells, if you will, coming off your hand, any part of your body. So the collar of my shirt is rubbing up against my neck. I am depositing DNA from myself onto my clothing, my jacket, my pants as my wrists are touching them. Anything that we come in contact with, it's not limited to the hands. It could be your forehead. If you're leaning up against a wall, you could deposit DNA from your person to an item.
Thank you, Mr. Pfeiffer. No further questions.
Yes, sir.
Anyone else? Any redirect? All right. May Dr. Pfeiffer be permanently temporarily excused as witness?
Permanently.
All right, Dr. Pfeiffer, thank you for your patience with us. I'm going to permanently excuse you as a witness. You're free to go about your usual duties and avocation. Just don't discuss your testimony with anybody except the attorneys in this case, okay?
Yes, sir.
All right, thank you, sir.
Thank you very much.
All right. State and representative from the defense, can I get you to come up, please?
Nuestro viaje comienza en la tierra de los sueños, donde las oportunidades florecen llenas de esperanza. Las primeras generaciones de inmigrantes cruzaron océanos, fronteras y muchas barreras. Ellos trabajaron sin descanso. Su sudor alimentó el suelo de esta gran nación.
Their sacrifice was our foundation. Now their children stand tall, ready to honor that legacy.
Hoy depositamos nuestros votos, no solo por nosotros, sino por todos aquellos que no pueden hacerlo. Hoy votamos para definir nuestro destino, para proteger los sueños de las generaciones pasadas y de las del futuro.
Unámonos, hagamos que nuestras voces sean escuchadas.
We build bridges and break barriers and forge a brighter tomorrow together.
Hoy nosotros votamos por aquellos que no pueden.
Okay, ladies and gentlemen, let me kind of just tell you where we are and let you know kind of the plan, the way ahead. I'd like to be able to delay our lunch just a little bit so we can take a witness, but the trade-off is that we're going to recess for the day after that particular witness, depending upon the length. Okay, so you get an early afternoon, and as I mentioned earlier, tomorrow, Friday, you'll appear for 12:30. We'll get started around 1 o'clock and work the afternoon. All right, so can we do that? Just we'll take another witness, see what the length of time is, and if it's where I think it will probably be, we're probably going to recess somewhere between 1 and 2 o'clock for the afternoon. Okay. All right. Call your next witness, madam or sir.
Your Honor, the state calls Mr. Eduardo Nava Flores to the stand.
All right, summon Mr. Nava Flores, please. All right, Mr. Nava Flores, good afternoon, sir. Sir, if you would please approach the witness stand. Once you get there, before you sit down, if you would turn and face Sergeant Ingram to be sworn as a witness, please. Stand up, please. Okay, there you go. All right.
So I first testimony, you give the truth, whole truth, nothing but the truth.
Sir.
Have a seat. State the spell your first and last name.
It's Eduardo Nava, EDUARDO NAVA.
Good morning, sir.
Good morning.
Did you, do you know or did you used to know a Miss Marcela Cisneros?
Maricela.
How did you know her?
I dated her.
And when did y'all first meet?
Couldn't tell you. I was 18, 2007, 8.
And back in 2013, did y'all have a relationship then?
Yes,
Were you all dating at that point?
I believe so, yes.
And was she ever a student anywhere?
Yes, she was a student in Kennesaw.
And when she was a student at Kennesaw, where did, in 2013, where did you live?
I was bouncing around. I didn't really have a house. I was staying at her place sometimes. I lived in Dalton sometimes with some friends. Sorry. Yes. Sometimes I'd stay in Dalton. Sometimes I would stay with her. Sometimes with friends. I was kind of bouncing around. Sometimes in my truck.
Understood. And did she live near where she was going to school?
I believe she lived at the school.
And did she ever have a car back then?
She did have a car.
What kind of car was it?
It was a red car. I don't remember exactly what model or make.
Did you have a car back then?
I did not have a car.
Would you ever use her car?
I would borrow her car, yes.
And on September 11th, 2013, can you describe to the jury how that day started?
I think it started normally. I think I needed to borrow the car. I don't think I needed it, but she let me borrow the car. I dropped her off at school, and I took off from there.
And when you dropped her off at school, did you have anyone with you?
No, I don't believe I did.
Did you ever pick anyone up?
I don't exactly know how I met with Brian, but yes.
And what is Brian's last name?
I believe it's Ranson.
And how did you know him?
I knew him for a couple of years. I don't exactly know how I met him.
And did he end up in her car that you were driving?
Yes, we ended up in the same car. We think we were headed towards the mall.
And where was that mall?
I don't exactly know.
In general, was it in Atlanta, outside Atlanta?
Don't exactly know what the outskirts of Atlanta are or is Atlanta. I considered Kennesaw Atlanta, so obviously I'm wrong on that.
That's fair. Did you have to travel far from the Kennesaw area to get to that mall?
I don't exactly know how long I've been driving, but we were driving on the interstate for a good minute.
And after y'all were at the mall, did y'all ever go anywhere else?
After that, we wanted to get some weed. I think Brian knew exactly where to get it, so he led me to the place.
And did he ever speak to anyone over the phone when you were with him?
I'm not exactly sure if he spoke with anybody.
So did he give you directions to where you were going?
Yes.
And when you got there, had you ever been to that area before?
No.
Do you know where that area is?
No.
Did Brian give you the address of where you?
No.
When you got there, what did you see? What was the location you all arrived to?
A gas station.
And when you got to that gas station, did Brian speak with anyone, whether in person or over the phone?
I don't think he spoke with anybody.
After that, what did y'all do at that gas station initially?
We waited for a minute.
And what did you do after waiting at the gas station?
We left that gas station.
Where did you go?
We went to where he knew where to get some weed.
And how close was it to that gas station?
I'd say about 15 minutes, 10, 15 minutes.
And when you got there, was it a house, an apartment? Where was this location you went to?
I believe it was a house. I don't think there was anything else connected to it. Maybe a subdivision, but I don't think it was, I think it was my house.
And when you all arrived, were you still driving at this time?
I believe I was driving, unless he took over at the gas station, but I'm pretty sure I was driving.
And did Brian, did Brian direct you from the gas station to that house?
Right.
And when you got there, what did you see?
Just saw a normal house. So we parked and got out.
Was anyone outside when you arrived?
I don't know if anybody was outside at the moment, but I think shortly after we arrived.
And did you ever go inside the house?
I might have stepped in for a second.
And who did you see when you were inside?
There was maybe, couldn't tell you the exact number, but there was a few people.
And
at this point, there were some outside, some inside.
Had you ever seen any of those people before?
No.
Had you ever been to that house before?
No.
Can you describe what were some of the people's genders, race that you were interacting with?
I believe Brian was the only white person there, Mexican. I don't believe there was any Mexicans there. There were some black people there.
And were you speaking with anyone there? Was Brian speaking with anyone there?
Brian was speaking with them. I didn't say a word while I was there.
And while you were there, why did you not say a word?
I wasn't familiar. I didn't know the people.
These mushrooms make you feel better. Like a lot better. These mushrooms make you feel better by keeping you calm and helping you focus. They keep you stress-free, but sharp enough to get things done. These mushrooms help reduce bloat and improve your digestion, so you can trust your gut instead of worrying about it. These mushrooms make you feel better. They boost your energy so you can embrace the day and help ease the aches and pains so you can get up and do it again tomorrow. So to recap, these mushrooms keep you healthy and energized, help your gut feel better and sharpen your focus while remaining calm. Oh, by the way, they taste good too. Someone should make a coffee out of this stuff. Rise. Feel better.
Were you, how long were you all there, roughly?
After we showed up until we left?
Yes.
A good hour or two.
Did you ever get any weed or what you were looking for?
No.
Where was your car once you went inside the house?
It was in the driveway.
And did anything ever happen with that car?
While I was in the driveway?
Correct.
No, it stayed in the driveway.
Did anything happen with the car while you were at this house?
Yes, it was apparently borrowed.
How did they get, as you say, borrowed? What do you mean by that?
Don't exactly know how this happened. I do remember being really faded, kind of in and out of what I would say consciousness. I was pretty messed up, trying to look for the next high. I don't really recall what the conversation was, but someone had mentioned that they needed a car, to borrow a car. Didn't expect mine to be borrowed. Next thing I know, my car's gone.
And had you said you were faded. What were you using back then?
Everything under the sun.
And was Brian using along with you?
Yes.
And did you all use before you got to the house?
I might have. I don't exactly know what he was on, but I was a regular pill addict. And
Understand. And are you clean today?
yes.
And do you recall on that specific day, what drugs you may have used either before?
I couldn't tell you exactly what I was on. I would do whatever I had in the cabinet that morning.
And did you where were the keys to the vehicle?
In the car, I believe.
And where were you when other people that wasn't you or Brian got in the car?
If I'm not mistaken, I was on the.
Same question, Mr. Foreman. You can rephrase.
Thank you, Your Honor. Did somebody else who was not Brian and you ever get in that car?
Did someone else other than Brian or me get in the car? I believe someone had to get in the car for it to leave. Yes.
And where were you when they got in the car?
I believe I was in between, inside and outside, maybe on the steps.
Did you see them get in the car?
Don't exactly remember seeing them get in the car, but I seen it pull off.
And do you remember after this speaking with anyone in the Atlanta Police Department?
If I'm not mistaken, we left the place just because we weren't getting any weed, we weren't getting anything, and it'd been a good minute, so we left. Closest place we could have possibly went to was towards maybe the gas station that we were at, and that's about what happened. We just left.
I'm gonna come back to where we were, but after all of this, do you ever remember
speaking with the? Yes, I think he was a detective that was around the car whenever I showed up to it.
And it was the same day that you arrived in the house, September 11th.
Right, it was the same day.
And it was Detective Quinn with the Atlanta Police Department.
I stand objection.
Was it Detective Quinn that you spoke with in the Atlanta Police Department?
I cannot reflect.
Do you remember speaking with him that day?
I do not know who Mr. Quinn is.
But did you speak with a detective on scene about the car?
Yes.
And was this, when you were speaking with him, was this before or after the car was borrowed?
This was before or after, sorry.
And when you gave him that statement, do you remember speaking with him in that moment?
Yes.
And did you, when you spoke with the detective, do you remember, or did you tell him what happened that day fresher in your memory when you spoke with him that moment?
At that point, I think I was just saying anything to get myself out of trouble. I was really scared of getting in trouble for buying weed. So I was fabricating a lot of things.
Did you tell anyone else, did you speak with anyone else other than the detective?
I think there was a bunch of news cameras there that I spoke to. I think I might have been on the news.
You spoke with the news?
Yeah. At that point, I told him something completely different than what I had told the detective.
Can you describe the person that you lent the car to?
I did not lend the car to anybody.
Could you please stop speaking your objections? It's objection basis. I don't need an explanation, Mr. Adams.
Did you ever loan the car to anyone, Mr.?
I sustain the objection.
Was that? Did you ever give the keys to Brian?
I don't believe I handed him the keys.
When you spoke with Detective Quinn.
Objection.
Basis.
Your Honor, may I?
What was the basis, sir?
Objection. Facts not an evidence. Form of the question.
Your Honor, this is.
Hold on. I stand as the form of the question.
When you spoke with the law enforcement officer, did you tell him that you gave the keys to Brian Ransom that day?
I could have said a number of things that were not true.
Did you tell the law enforcement officer that you gave the keys to Brian Ransom on September 11th?
I do not.
Did you How many, did you see anyone who's
question?
Do you recall telling Detective Quinn that you saw 4 black males get in that car?
Objection, assumes facts not in evidence.
I'll overrule that, sir.
I do not recollect anybody getting in the car.
How long did you stay at the house after your car left that location?
Been about 2 hours.
That you heard police sirens?
No, I do not. No, it was a good bit.
Did you ever see that car again after it left the house?
After it left the house, yes, I saw that where it was wrecked.
How did you know where to go?
We just went to the nearest gas station.
Do you recall telling Detective Quinn that you heard police sirens and followed him to the car?
No, once we started walking, we saw all the police, and luckily we were already out, and we felt something was wrong, so we went towards where they were going. Coincidentally, they were going the same way that the gas station was at.
So your testimony is coincidentally all happened. Walk to the car where they ended up.
No, we went to the gas station
Your car had left.
only once we started walking towards the gas station.
Did you interact or see, did anyone at the house you were with ever say anything about any police that came by?
I don't believe so.
You don't believe so?
No.
Did anyone at the house seem to, that you were with, you did not know?
Save more when you go all in with Cox. Get Cox Internet and one unlimited mobile line for just $80 a month. All with Wi-Fi equipment included and no annual contract. Get fast, reliable internet at home and unbeatable 5G reliability on the go. Plus, faster, more reliable speeds than T-Mobile 5G home internet. Get Cox Internet with Wi-Fi equipment included, no annual contract, and one unlimited mobile line for just $80 a month. Call or learn more at cox.com/value.
Have any reaction to any police sirens that came by the house?
I don't believe so. I think it was just me.
Why did you get a feeling about your car that you just tested?
Because I'd been there for a very long time. My car had not returned, and I couldn't get a clear answer on where my car was. I didn't know anybody there, so my first thought was that my car was not in the right hands.
Why did they take your car that day?
Also speculation.
I'll stand the question.
What was your personal understanding of why the car you drove there was needed to be used by somebody?
Objection, calls for speculation.
One of the question does, I'll sustain it.
Not exactly why, but you yourself, who was physically present, what was your understanding of when your car left? Did you think it was stolen? Did you think they were going to the store? Did you think they were going to church? What did you think your vehicle was traveling to?
I do not exactly know where they were going to. I had heard something about them needing cigarettes or diapers.
Did you expect that your car would be brought back?
Well, yes. Once I knew that it was gone, I rechecked with Brian, just kind of asked him what was on my car. He said, "Don't worry, I'll be back." So at that point, I probably kept smoking and just kept sitting around. I almost remember falling asleep for a second. It was so long, and then waking up and my car still not being there, just kind of being in and out, and yeah, finally taking off.
So Brian knew where your car went as well.
Objection, leading.
I stand the question.
You just testified that Brian told you it's cool. What did you mean by that?
That everything was okay, that I didn't need to worry about anything.
So was Brian aware that your car left?
Objection, calls for speculation.
I stand the question.
What did you take Brian to say that it's cool after the vehicle you arrived there with?
I said, "Where's my car?" He said, "Don't worry about it, I'll be back."
When you asked him, "Where's your car?" he said, "It's cool, don't
Objection
worry."
to the hearsay, calls for hearsay.
Your Honor, this is his direct testimony a second ago.
I'll overrule the objection, Mr. Adams.
Sir, when you just said, you asked Brian, "Where's your car?" and he said, "It's cool," were you under the impression that Brian knew where your car went?
I was under the impression that, yeah, that my car went somewhere and that somebody knew where it went. If I felt like like no one knew where I went, I probably would have left and looked for my car.
At that time, he told you that it was cool. How did you react to that?
At that point, I was just content. I was cool.
What address did you and Brian Ransom arrive to?
To when we found the car,
Correct.
at the same gas station that I think we stopped at.
When you first got to that house, you didn't know anybody.
Mhm.
What address was that?
I do not know the address.
Do you recall telling Detective Quinn it was 2233 Macon Drive where you and Brian Ransom arrived to the car?
Absolutely not.
Improper foundation for refreshing recollection.
Your Honor, this is impeachment, not refreshing recollection.
I'll rule the objection.
Do you recall what any of the males who got in your car were wearing?
Objection to the form of the question. And mischaracterization of the evidence.
I'll rule the objection. You can answer the question, sir.
What was the question again? Sorry.
Do you recall what any of the males who got in your car were wearing?
Absolutely not. No.
Do you recall telling Detective Quinn that one of the guys was wearing a white shirt, a white t-shirt?
No.
Do you know how quickly they got into your car when they jumped into it at that house?
No.
Do you recall telling Detective Quinn that the 4 black males got in your car like this?
At that point, I was telling whoever the detective anything to get myself out of the situation.
Did you ever tell, before you talked to Detective Quinn that day, what did you and Brian ever speak together about what you would tell the police?
I don't believe so.
Did you ever tell the police, did you initially tell the police that your car was borrowed from that house?
I think initially I said that I was at the gas station. It got stolen from the gas station.
So your first statement to police was that the car was stolen?
Yes. It was recorded and then he erased it and he re-recorded it.
Re-recorded?
Another statement. He said, that's lies. Tell me the truth. He said, I'm going to delete it and record again. I said, okay.
You're talking about the detective?
The detective. Yes, sir.
Do you recall telling Detective Quinn exactly do you recall telling Detective Quinn that you and Brian initially told the police that the car was stolen, but now you're going to tell the truth?
I don't get the form of the questions here.
Do you recall telling Detective Quinn that initially you and Brian told them that the car was stolen, but now you're going to tell the truth about what really happened?
Yes, I believe that's the case. We initially said it was stolen just to get everybody out of our hair. And yeah, that was not true.
And you and Brian discussed what you would say to the police before you gave the first statement?
I stand the questions to form.
Did you and Brian discuss that story of the car being stolen before you first spoke with the Atlanta police detective?
I don't believe so. I think we just kind of both thought that was the best answer. And I believe that's why he erased the first statements, because he separated us and asked us and they didn't match up. So he recorded it again. Excuse me.
When you spoke with law enforcement on September 11, 2013, were you in a courtroom?
No.
When you spoke with law enforcement on September 11, 2013, were there television cameras
I believe there were television cameras.
that were directly listening to you and the detective's conversation?
No, they came at me before I spoke to the detective.
Were all these people that are currently in the courtroom around you when you spoke with the Atlanta Police Department detective on September 11, 2013?
The question was there anybody here?
Correct.
No.
And sir, today, you don't remember anything of what you told the Atlanta Police Department detective on September 11, 2013?
I stand objection.
Sir, do you recall what you told the Atlanta Police Department detective on September 11, 2013?
I do not recall what I told him exactly now.
Thank you, sir. No further questions.
Cross.
Now, Flores, good afternoon, sir.
Good afternoon.
All right. It's fair to say you don't remember a whole lot about that day back in 2013, 10 plus years ago. Is that true?
That's true.
All right. You do remember some things, right?
Vaguely.
You do not know who the police officer or detective or investigator was that you spoke to. Is that right?
No, I do not know.
So when the prosecutor keeps asking about Detective Quinn, you don't know if it was Detective Quinn you spoke to or someone else, right?
No, and ever since then, I've been getting a lot of calls from different parties. Not exactly sure which side of the party it is.
Okay.
So I've had a few different statements over the phone and stuff like that. They're probably all different.
All right. Whether or not it was Detective Quinn, you do remember speaking to someone that day, a law enforcement officer, right?
Right.
And fair to say, my words, but you lied through your teeth to the officer.
Basically, at that point, I was saying anything I could to get myself out of the situation, and a lot of things were fabricated.
But one thing that you do recall is that whoever the law enforcement officer, the detective on that day was that you spoke to, you gave him a statement, and then instead of keeping that statement, that law enforcement officer erased your statement that you gave initially, and then went ahead and recorded something else, right?
That's what I was told, my understanding of it, yes.
Okay. Now, chronologically, going from the beginning, you're dating Miss, at that time, her name was Cisnera.
Yes.
Marcello.
Mm-hmm.
Right? You're dating her at that time, you borrowed her car on that day.
Yes.
At some point, you end up in the car with Brian Ransom. That's your friend.
Right.
His nickname is Skateboard, something like that, right?
I don't know about that, actually.
Okay. Brian Ransom is his name.
Right.
Okay. Y'all end up together. Y'all are, I think you said you were headed towards the mall, right?
Right.
Ultimately, y'all are going to go try and buy some weed or try and buy some drugs. True?
At the very initial, it wasn't that case, but after we left the mall, yes.
Okay. Brian knows where to go get some weed or to go get some drugs, right?
Right.
You were already high.
Yes, I was at that point in my life, I wasn't doing very well. I was waking up faded, going to sleep faded.
Okay. All right. Fair. And so you all end up in some part of Atlanta, you don't know where.
Right.
Okay. You all go to a gas station. True?
True.
You all meet up with someone at the gas station.
I'm not exactly sure if we met up with anybody at the gas station after the mall. I think we just stayed there and stalled. Maybe my understanding was that we didn't know where we were going.
Okay.
Could have possibly been that we were going one place and he switched it up on me.
Okay.
At that point. It could have been a number of things of why we were there. I didn't ask questions. Like I said, I was in there nodding out on the car.
Okay. Okay.
Ready for him.
Go from the gas station, you end up at a house. All right. No one forced you to the house, right? No one came and kidnapped you from the gas station and said, hey, come on over to the house, right?
No.
Y'all end up at the house because y'all are there looking to buy some drugs.
Right. True.
Y'all get to the house. Y'all are there trying to get some drugs. At some point, I heard you say you're kind of faded. You're in and out of it.
Right.
The car leaves at some point, right?
Right.
You don't know what the circumstances were under the car leaving, right?
Right.
You ask a lot of questions about the men getting in the car, the males getting in the car. You don't know who got in the car.
I do not know who got in the car. I did not see that.
Okay. So Brian is there too, Ransom, right?
Right.
Car goes at some point in your head, you're like, car ain't here, better go find a car.
Right. I don't exactly know how long it was before the question of someone needed to borrow a car and it leaving. But I do remember it was a question, and maybe since it didn't leave right away, I didn't really think that it was going to be my car that they were taking. Okay. So once I noticed that it was leaving, I definitely asked Brian what was going on. He said everything was okay.
Okay. Some point you and Brian, I think, end up going down to the gas station, right?
Right.
Okay. Car's wrecked.
Car's sold.
Because you got her car.
Right.
Her car's been wrecked.
Like my drug use, not gonna like why I was there.
Okay. And at some point you end up speaking to law enforcement. Right. Your main concern at that point is trying to not get in trouble for being high and out driving around, right?
Right.
Being at some location trying to buy drugs, right?
True.
Being at some location taking drugs,
True.
right? You end up, in your words, lying to the police officers or whatever detective.
Not being very truthful with my words.
Okay. I think you said that you were going to tell him anything you could at that point to get out of trouble.
At that point, yeah.
All right. So whether it was, someone took the car at the gas station, or someone stole the car from some location, or someone took the car from the house, whatever it was you needed to say, you were going to tell law enforcement at that point.
True.
And you did, right?
True.
Okay. Now, at some point, did Maricela have to come and pick you up, or did you make it back up to where she was?
No, I think I had called her and she came pick me up in her friend's car.
Okay.
I think her friend was with her.
I want to ask you something about after you spoke to the law enforcement officers, right? By the time you get done talking to them, there's a couple things that you have done. True, you have been out buying drugs, right?
Right.
And you have given a false statement to the police that they appear to know is false, right?
True.
Okay. Were you?
Objection, Your Honor. Basis. He said that they know.
What's the
false.
basis? What's the basis?
Speculation, Your Honor.
Overruled.
At any point after, and this is September the 11th of 2013, at any point after that day or after that day, did anyone ever come back and charge you with either purchasing or attempting to purchase or purchasing drugs?
No.
Did anyone, any APD, detective, investigator, DA, anything, come back and charge you with giving a false statement to the police?
No.
Anyone ever charge you with any sort of RICO racketeering charge for any of that stuff?
No.
Basis.
Relevance.
Overruled.
Sounds like you were in a bad place back then.
Yes, sir.
Things better?
A lot, sir. Thankfully, until this came up again.
All right. Listen, I appreciate it. That's all I got. Thank you, Judge.
Any other examination? Oh, hold on, Mr. Atkins.
Yes, Your Honor.
All right. You, Mr. Brown, are very eager today. All right, come on. All right, Mr. Short.
Good afternoon, sir.
Good afternoon.
Just a couple questions for you. My name's Max Shard. To your recollection, when you arrived at the scene where the car was, did you observe any individuals lying on the ground? Did you see anyone who had been shot?
I did not see a person that had been shot. I'd seen a lot of blood.
You saw blood. Was that by the car?
It was by the car.
Okay. how many, you said you spoke to law enforcement. Did you understand that person to be a detective or just a police officer?
By the way they're dressed, without a badge, or maybe he had a badge, just not visible, with a suit like yours, I thought he was a detective.
So this gentleman was in a suit and it was a male?
Yes.
Okay, and you only spoke to one police officer
I believe there was more than one.
that you spoke to?
I believe so.
Okay, the gentleman in the suit, is that the person who erased your original statement from their recorder?
Yes.
Okay. And I know that you said that you don't recall that gentleman's name.
Right.
Okay. Do you recall what that gentleman looked like?
No.
Do you recall the race of that gentleman?
I believe he was black.
Okay. You said he was African American?
Yes.
Okay. Was there anything else you recall about the way that gentleman looked? The gentleman that erased your original statement?
Do not recollect how he looked.
Was there any other law enforcement, to your recollection, that recorded any statements?
On that day?
Yes.
No.
So it was just one?
I believe so. Unless the camera that was there before asking questions that was part of the news, but it was briefly 2 seconds before the detective got to me and crossed me over the yellow line.
And it was the same gentleman that took your statement
Right.
that erased your original statement?
Right.
Okay. Thank you. I have nothing further.
Anybody else? Mr. Matthews?
Good afternoon, sir.
Good afternoon.
Just one or two questions. You remember when the prosecutors asked you moments ago whether anyone in this courtroom was present when you talked to law enforcement back on that day?
Right.
You remember saying no, correct?
Right.
And has anyone in this courtroom pressured you or coerced you to get up here and testify as you have this afternoon?
No.
Okay, thank you. No further question.
Anyone else? All right, redirect.
Thank you, Your Honor. Sir, on cross-examination, you were asked that you don't know the circumstances of the car leave. You remember that?
The circumstances of how I left, right.
And on cross, you were asked again, you don't know who got in the car.
Right.
Remember that? And on cross, you were also asked, you don't know anything about this situation, right?
The situation, which situation?
You were asked that.
Objection, Your Honor. These are all asked and answered.
I'm gonna sustain the objection on other grounds, so it's all leading, so is your witness on redirect?
Yes, Your Honor. When you spoke with, what exact location were you at when you spoke with Detective Quinn?
I was beside the car.
Is that the intersection of Macon Drive and Cleveland, if you know?
I do not know.
Is your birthday February 10th, 1990?
No.
What's your birthday?
February 2nd, 1990.
Did you tell Detective Quinn your birthday was February 10th, 1990?
Absolutely not.
You didn't lie about your birthday?
No, that I did not lie about.
And when he started recording, on the recording, Detective Quinn told you he just walked up, right?
No, I waved him down because he was walking around the car. There was a yellow tape all the way around it, maybe 30 feet away from it, 40 feet away from it. The whole parking lot of whatever establishment was there that it wrecked into had yellow tape all over it. I stood at the yellow tape, kind of yelled at him a couple of times. He turned around, didn't pay attention, yelled at him again, said, "That's my car." He came up and asked me the questions.
And what was the main reason that you walked up again?
Because we were trying to leave the situation and possibly find my car. I was tired of being there, not getting any weed, and my girlfriend had to be picked up soon. So I was hoping that we could do something. Sometimes maybe we get to the gas station and ask for a ride from someone just to get back home or something.
And did you ever see a wrecker or a tow truck when you were talking to Detective Quinn?
No.
Did you ever hear the sound of a wrecker or a tow truck when you were talking to Detective Quinn?
No. Of an actual tow truck?
Something getting the wrecked Nissan off the ground.
No, it was still definitely.
Of a wrecker moving that Nissan.
No.
Do you remember if the detective asked you who you gave the car to?
I do not recall what he was asking.
Did he ask you that?
I don't recall that.
And after he asked you that, do you recall what your answer was?
I don't recall answering that question.
You told him you didn't give the car to anyone except Brian, your friend?
I could have made that up as far as giving Brian the car. I didn't let anybody borrow the car.
I'm not asking you if what you said you made up or didn't make up. I'm just asking you what you told Detective Quinn on September 11th.
I do not recollect what I told him.
And sir, whose idea was it to borrow? Who brought it to your, did anyone ever bring it to your attention that that car needed to be borrowed?
No, I just overheard.
Did you tell Detective Quinn how you came to know that that car needed to be borrowed?
I do not recall telling what I told the.
You didn't tell Detective Quinn that Brian told us some guy told him to borrow the car?
I do not recall that. No, that sounds a little fabricated.
Did the officer you were speaking with ever tell you to cut to the chase?
I don't believe so. I mean, he was being pretty blunt and pretty blunt with his words. He was being pretty cool. Wasn't really.
To me when he told you that. Did you think he believed your first story? Speculation.
Hold on. I stay in the form of the question. You can rephrase it.
Sir, or when you speak with someone and they tell you that what you just told them was bullshit, how do you take that as a person?
As a person, if I'm lying, I understand that and I take it as I'm taking bullshit. And if I'm not lying, I say that they're full of bullshit.
And if someone tells you that, or you tell someone that, does that mean that what they just told you don't believe or you do believe?
Possibly that I don't believe them.
Now, did you ever get lost when you and Brian rode to this house?
I felt like I was lost the whole time.
Did you know any of the street names?
No.
Did you let Brian Ransom borrow the car?
No.
You recall telling Detective Quinn you entrusted Brian with the car and you let him borrow the car?
He never borrowed the car. He was never in the driver's seat of the car. I don't believe I handed him the keys at all.
I'm asking you what you told the detective on September.
I do not recollect what I told the detective.
Did you hand Brian the keys to the 2004 Nissan?
No. I believe the keys were in the car.
Did you tell Detective Quinn that you gave the keys to Brian?
I stay in the question. That was Mr. Shard and Mr. Harvey, I believe. Who?
Did you ever tell Detective Quinn how short or long one of the male's hair was that entered the Nissan Altima?
No.
You never told him that?
Not to my recollection.
And you testified and were asked on cross about when Brian told you it's cool. The people just took your car. You remember that?
Right. He just told me the situation was cool. He didn't really explain what was cool about it.
And after he told you that, how quickly was it that people got in that car?
I couldn't tell you. Maybe 20 minutes, 30 minutes.
So your testimony today is Brian says it's cool, don't worry about it, and 20 or 30 minutes passed before we could get in the car.
Oh, no, the car was already gone whenever he told me it was cool.
Do you recall telling Detective Quinn that Brian told you it's cool and 4 people jumped in the car?
I do not recollect that. I did not see anybody jump in the car.
And when people got in the car and you realized the car left, was there anyone else at that house?
I believe there were still some people left there, yes. Yes, because we stayed there and we still smoked and got even higher.
What did y'all smoke?
Marijuana.
And did you ever tell Detective Quinn if you felt like Brian knew the person who just left out of the car?
Excuse me, one more time.
Did you ever tell Detective Quinn that you felt like Brian Ransom knew the people who borrowed your girlfriend's car?
The whole time I believe that Brian knew them. Yes.
And specifically the people who got in the car?
I believed he knew everybody. So not specifically, but I felt like everybody, he knew them. So obviously, yes, I believe that.
And was your car being used, was it being used as a favor?
I don't know if he actually was doing that favor for them or what.
Didn't you tell Detective Quinn, obviously this dude knows this guy is doing a favor?
Well, that's what I would assume, yes.
So that's what you told Detective Quinn?
I don't know if that's what I told Detective Quinn.
Had you ever been around the guy that you went to party with?
No.
And was the gas station that you first went to, was it nearby or far away from the house?
Pretty far away, I believe. I think it was 10, 15 minutes.
You didn't tell Detective Quinn that the gas station was somewhere near?
Near enough to walk to it.
So was it far away or near?
Depends what you consider about far on walking, maybe like 20 minutes.
And did you ever tell Detective Quinn that you never even went to a gas station?
No,
You never told Detective Quinn that?
not to my recollection. Like I said, at that point, I was telling him a lot of lies.
And when you first walked in the house, was Brian talking to anyone?
I believe he was the only one talking.
Did you see any guns in the house?
No,
Did you see any guns on anyone?
no.
What direction were the police sirens that came by the house?
What direction?
Yeah, where were they going?
It sounded like they were going away from the house.
And was it multiple cop cars or just a couple who went by the house?
It was a few of them with their sirens on.
Did your stomach drop when you heard police sirens?
Not really.
Did you have any thought that it was related to your car that you slept?
Not at that point, no.
Did anyone at the house, when you saw the police sirens going by, did you ever tell Detective Quinn about any of their reactions to that?
No, like I said, we were getting ready to walk off, and that's whenever I heard it. I don't think I made a big deal about it. In my head, I kind of suspected maybe that something wasn't right, but everyone else just kept on their cool, just like the whole time. And I just felt like the only outcast thinking too much.
You didn't tell Detective Quinn that the guys who were there did not say nothing, they just had this look in their eyes?
No.
You never told Detective Quinn that?
I don't recall telling him that, and if I did, that's not really true. I don't remember.
Did anybody roll by that wasn't a cop, honk their horn or do anything like that when you were at the house?
No.
You didn't tell Detective Quinn that guys rolled by, said, "What the fuck happened?" and started honking?
I don't believe so.
Did anyone at the house start making any phone calls after these police sirens started swarming by the house?
No.
You didn't tell Detective Quinn that the guys in the house started calling?
I don't believe I remember anybody at the house at that point doing any kind of calling to anybody.
Did anybody at the house speak with you? Or did anybody at the house, after the police sirens were rolling by, make any reference to the people who just left it?
Objection, hearsay.
I'll sustain the objection.
Without saying what they said, did you ever tell Detective Quinn that anyone in that house said anything within earshot of you in relation to the 4 people who just got into your car and took off?
I don't remember. No.
How did you get to the car?
Walking.
How did you know where to go?
I believe at this time I'm still following Brian. He's the one with the GPS, and I'm just floating around.
After your car was borrowed, how did you know to go find the 2004?
I was tired of waiting.
How did you know where to find it?
It was just the nearest gas station, and we didn't know where to find it. We just wanted to get to a gas station so we can call someone to pick us up or something. We ended up at the gas station where there was yellow tape.
When you talked to Detective Quinn a couple hours after this, you didn't tell him the only way they went to the gas station? Your Honor, if I...
Hold on. Facts not evidence?
Yes, sir.
I'll sustain the question as to form. You can go ahead and rephrase.
Yes, Your Honor. When you talked with Did you talk to Detective Quinn the same day that your car was borrowed?
I talked to a detective, yes.
And was that days or hours later from when the car first left the house? And how long was it?
It was hours.
It was a couple hours?
I believe it was a couple hours.
So it wasn't all that long?
No, but my recollection of time is pretty phased out.
So is it fair to say that you talked to Detective Quinn with what you just testified to a couple hours after the car was taken? Is that fair?
Yes, I could be wrong. It could have been 4 or 5 hours.
In general, a couple hours is fair to characterize?
A few hours, yes.
So a few hours after your car was taken, borrowed, do you recall telling Detective Quinn that you were walking, the only way you could find it was to follow the cop lights? Did you tell Detective Quinn that?
No, that was just, I don't recollect telling him that, no.
Did you ever tell Detective Quinn about if you wanted Brian to get you in trouble?
No.
You didn't tell Detective Quinn that you didn't want your buddy to get in trouble?
At that point, I didn't want me or him getting in trouble because we were there purchasing weed, and I thought that's what the main problem was.
Did you tell Detective Quinn that?
I don't believe I told him that. I don't recollect what I told him.
At the very end, when you were speaking with the detective, do you recall what you told him?
No, I think at this point I had told 3 different stories.
Did you tell Detective Quinn that this interview is the absolute truth?
Don't exactly remember that being said.
Have you been following this case since you were being testified?
No.
How did you feel when you got subpoenaed?
I felt like it was a jury duty thing. I didn't pay much attention to it. My involvement in this was very small. I thought it could just blow over. And no, I kept getting bothered. My mom kept getting bothered. My brothers were getting bothered. So I just kind of felt I should see what's up with it. And now I know the grand scheme of it, I feel like, or at least how more complicated it is than what I thought. So.
That's fair. Has this case caused any trouble in your house?
Yes.
Why?
This is something I wanted to put behind me. This is something I didn't want to ever really, I didn't think it was going to be like that. I've worked so hard to get myself straight. I'm a recovering heroin addict. I've been through a lot, and I feel like this was way in the past, and didn't really feel like bringing up this story to any one of my family members. Ever since they have found out that I am the one with the RICO charge. So it is very, it's sad, to say the least. Were
you ever offered to have anyone from the DA's office come meet with you and talk about that day?
I don't exactly know who has been calling and wanting to meet, but there's been very many people, I believe, calling to want to meet for testimonies.
Why did you not let them come meet you and talk about it?
Because I thought my part in this was very irrelevant.
Did they ever ask you if they could meet on Zoom?
Don't recall that.
Did they ever ask you if they could meet on Microsoft Teams?
Don't remember that. I don't even know what those are.
Did they ever ask you to speak over the phone?
That I have spoken over the phone.
Did they ever ask you to talk about what you remember from that day over the phone?
Several times.
Did you only want to speak on the day of your testimony?
I felt like it wasn't necessary. I didn't, honestly, to this day, didn't think I needed to speak ever.
Did you ever say if you got an email, did you have to read it?
I don't read emails. That's just.
Did you ever get the marijuana that you went to that house to buy?
No.
Thank you, sir. No further questions, Your Honor.
Redirect, Mr. Adams. Or recross, I should say. I apologize.
Sir, let me ask you just a couple questions. When you were talking to the law enforcement officers or the detectives, right, on that day, isn't it true that they told you, or they were telling you things that they thought they knew? Does that sound about right?
Don't exactly recall them knowing what was going on. They did explain to me afterwards. I asked what happened to my car, and they briefly explained what happened.
So they told you, they gave you information.
Basically, yes.
In addition to asking you questions, they're telling you stuff as well, right?
Right.
All right. You were subpoenaed to come here today, weren't you?
Right.
Okay. Time did you get here?
Got here at around 11.
11 o'clock. All right. You were subpoenaed, as you understand it, by the district attorney's office, right?
Right.
Okay. From the time that you got here, did anyone offer to take you upstairs and let you look at your statement, your old statement, or any recordings or anything that you had given from back in 2013?
The question was, has anybody?
Yeah. Did anyone from the DA's office say, hey, you're here, come upstairs and talk to us, and we'll tell you what we're going to
Yeah, just a second ago, I talked to these two people.
A second ago?
Yeah, just right before I walked in.
Right before they brought you in?
Yes.
Okay. Over the course of the past number of months or past couple of years, anyone ever, I mean, you live somewhere, you have a home, right?
Now I live with my girlfriend, yes.
Okay. Anytime over the course of the past few months, anyone come to your house to attempt to interview you there at your house?
Not personally in my house. They have came to my mom's. They have came, they've called my brother. I don't believe they've came to my work yet, but I think that was what they said they would do.
Okay. All right. The DA asked you a question a little while ago, right, about whether at the end of your statement interview, you said something to the detective or investigator, whoever it was, about whether everything you said is the absolute truth or something like that, right?
Right.
Your response, if I heard you correctly, was if you did say that, it wasn't true, right?
Right.
You told, I think in your words, at least 3 different stories about what happened that day.
Yes.
It was clear that a lot of things that you told the detective, a lot of things that the DA was asking you about, whether you said to the detective, just wasn't true, right?
Right.
Okay. You don't have any idea what happened with the car once it left your presence until you saw it again. You don't know what happened, right?
I have no idea.
You're not able to tell this jury from any personal knowledge that, hey, this person got in the car or that person got in the car or the car went here or what happened. You don't know anything about that?
No, it was just all what I was being told.
Yeah. You had the car, and then at some point later on, you saw the car was wrecked, right?
Right.
That's all I got. Thanks, sir.
Mr. Short, anything?
No, Your Honor.
All right, Mr. Matthews?
No, Your Honor, thank you.
All right. Anything further, Mr. Atkins?
No, Your Honor, and this witness can be permanently excused.
All right. Okay, Mr. Nava Flores, we're going to permanently excuse you as a witness. You're free to go about your usual duties and avocation. Just don't discuss your testimony to anybody except the attorneys in this case, okay?
Got it.
Right.
Thank you, Your Honor.
Thank you for your patience with us. All right. All right. Ladies and gentlemen, given the hour and given what counsel have indicated to me, this might be a natural stopping point for us for the day. So let me go ahead and just kind of just recap where we are. So tomorrow, what time are you supposed to be here? 12:30. Okay, and we're going to work a little bit in the afternoon, and then the next time we'll be here will be Monday morning. The 26th, and if I could have you all here for 10:30, okay? We'll anticipate 11 o'clock start time. All right, we'll probably work till sometime deep in the afternoon. All right? And then I'll kind of give you the breakdown of the days after that. We're still going to be down, as I mentioned, for administrative days from the 5th through the 12th of March, okay? All right. What are your ministerial inquiries with me, ladies and gentlemen? And bless you. Anyone?
The day of the 27th.
Say again?
February 22nd, is that a full day?
That's Tuesday.
Correct.
That may be a partial day. Okay, and I'm thinking about we work during the morning because the court has some unrelated business related to my duties as a chief that I may have to take up in the afternoon. So looking at my calendar, that would be a reasonable hypothesis. We go a couple hours, 3 hours in the morning. Okay, on 27th. Anybody else have any other questions? Anyone? Okay, let's review again. Leave your notepads in the basket, take a sticker. Please do not discuss anything that we have talked about or you've heard in open court because, of course, you have not been given the instructions by the court, so it would be error for you to, or for it to be a violation of this court's admonition for you to go ahead and do that. Do not discuss the matter as you're going to wherever it is and how you're traveling to and from the courthouse. Don't talk to it about the case with your relatives, friends, and well-wishers. Do not go on any third-party sites or listen to any news accounts or any other reviews of this particular case as it's going on. Because remember what I told you, you can't consider those sources. You can only consider what's being presented in this courtroom. If anybody should try and talk with you, reach out to you, otherwise contact you, of course, you let Sergeant Ingram and myself know immediately. Okay. And again, ladies and gentlemen, I can't thank you enough for your patience and your flexibility with us. And I say that on behalf of all of our advocates and parties. Okay. Unless you have anything else, anyone going once, twice. All right. So tomorrow morning, ladies and gentlemen, 12:30, right? Yes. Okay, all right. For anticipated 1 o'clock start time. All right, enjoy your evening, ladies and gentlemen, and we'll see you tomorrow, okay? All rise. All right, get some jingle around. All right, ladies and gentlemen, please be seated. Our jury has left us. All right, anything I need to be made aware of or take up before I recess you all for the afternoon? Yes, Mr. Adams. No.
I thought you had said previously that we were going to be off on the 27th. Was I wrong about that? Welcome back here.
We're all no, I don't believe I've gone that far as that, yeah, at least that day in terms of telling you what I was going to do, but it would probably be sufficient that we will probably start around, take a couple hours of testimony. I would say probably between 9 and around 11:30, and then we probably recess for the rest of the day. So I can take up some other things or motions depending upon that time, okay?
All right, thank you.
All right, anybody else?
Your Honor, as it relates to the open records request, we are working on those. I wanted to give the court an update that, yes, and I wanted to make sure that the court was aware that we are working on those right now as we speak and have been since we left the court yesterday. So we will give the court and the parties the most current update we have after we are able to confer with our team after we leave the court's presence in a few moments.
Let me ask you all a scheduling question since the 27th, we're going to be here a couple hours. Do you have motions that or other matters we can take up?
Yes, sir.
All right, why don't we, well, go ahead, sir. What do we have that we can take up for a couple hours on that morning? Because then I can recess or I can give our jurors that particular period off.
Your Honor, we have, yes, we have motion limine number 38. It's just argument. 39.
Hang tight. Okay, 38.
Yes, sir. 38, 39, 41. Those are the ones I'm showing right now, sir. For Mr. Williams. None of them, though, is any witness. So, it's just, I don't believe that they're going to take a tremendous amount of time. Maybe an hour total, but I'm, just estimating, and you've told me, and other people have told me I do not do time work very well.
Now, none of you all estimate time very well. Whatever lawyers tell me, I double at a minimum. Mr. Brown told me 20 minutes for a certain witness, and we took 2 hours. So, my confidence is low on attorney estimation time. All right. However I say that. Okay. Wes, you have, I have 38. I don't have 39. Okay, fine. And then, okay, so Mr. Williams has 38, 39, 41. And then also there is a motion for production of supposed visitation.
That was done, sir.
It's done?
That was correct. My knowledge, that was satisfied by the city.
All right, can we produce an order? And Ms. Love or Ms. Tilton saying that's been done?
Yes, Your Honor.
All right, thank you. What about the motion to exclude or redact Mr. Winfrey's conviction?
That's true. We need to argue that one if the state intends to put that in evidence. I assume they do, but I guess
I said, I also, yeah, is that the state's pleasure at this point in time, or do I need to
You
defer?
do need to be heard on that because we don't intend to redact.
Okay, all right. What about, so we'll hear that. And what about the motion for notes recordings for Mr. Derek Wise?
Your Honor, we can respond to that because there are none, but we can respond on.
Okay, all right. So I'll try and take up as many of those things starting at, Thanks. Okay, so what I'll tell our jurors tomorrow is that we'll have an administrative day on the 27th. That's when we'll take up those motions that we've just mentioned in regards to Mr. Williams. Okay, another pressing issue I need to resolve with you all is our juror issued juror, I believe, 204. Who's gonna move? Because her lease starts on the 24th of February. So have you all found any other case law or any other authority that I may be able to consider? So I think that where I left it was, it's the court, from looking at the case law, there are no really cases on point. The only thing that the court is concerned about is at the time of the verdict, she would no longer be a Fulton County resident. And it's not a question like where it's waived and we didn't find about it beforehand. Well, we found out beforehand. This is just something that's come up. So what are your thoughts?
So, Your Honor, we were still researching that issue, and if the court will permit us to address it at the end of court tomorrow, given that we're still.
I gotta tell her tomorrow.
Right.
Because I don't want to wait till the end of the day. Okay. Because I do need to rule on the issue so that she's apprised of that, because her lease is effective the 24th.
Or at either the end of today or at very earliest tomorrow before we begin court, if the court will allow us at that moment. I can have a one-word answer, for the court. But I just want to make certain with respect to the case law that we are clear on it, because I am where the court is now regarding.
Latina Power fuels our democracy. Exigimos respeto por nuestros cuerpos y por nuestras vidas. Everyone knows it. Women's reproductive rights are fundamental to democracy in a free country. Georgia es nuestro hogar. Nuestro voto puede redefinir políticas que le dan forma a esta nación. We're not just voters. We're architects of change. Vote. Vota. Because her right to choose matters.
Running a business comes with many moving parts, and being able to keep track of it all makes all the difference, especially when it comes to stock.
Not having a case on point, and I just wanted to be as thorough as we could, because I am concerned as well, and if it is as we suspect it is, we will have no objection, but I just wanted the opportunity to make certain of that.
Y'all have had a few days already. It's not the first time I've brought this up, so, you know, I that's why I'm asking about it today, because I gave everybody the opportunity to take a look at it. So, you can have till tomorrow morning, but I want to take it up first thing, so, at 1 o'clock.
Okay.
Mr. Steele, anybody else, you find anything?
I could give you the case, but all the case of what I told you, we're not waiving any issue, and that's always what comes up. I'm being upfront with the court. I'm not waiving it. We believe that she needs to be removed. You don't remove her, we understand, but for appellate purposes, I don't want to catch the court blindsided up. It'll be raised on appeal, God forbid, as a conviction.
Anybody else? I haven't been able to find any case law on this particular point. It falls on the court's discretion. I think she was it's not like she committed misconduct. It's not like she didn't tell us. So, and it's just the eventuality that came up some 10 months later after she said, well, I'm thinking about moving. So.
And to be clear, we don't find any case law. We are not going to be objecting. I just wanted to, you know.
I just want to know if you all found anything else, because of course my preference would be to have her stay, but I don't, you know, she got a First Amendment right to move where she wants to, and I can't kind of abridge that, but my ultimate concern is whether or not if and when there's a verdict that she's not lawfully a resident of our county, and that's where I think the challenge would lie. I don't know what an appellate court would do or later, depending upon circumstances, but you know, I just have to kind of think about that. Okay. All right. So we'll take up that first thing tomorrow. And other than that, anything else for me?
I look back, Your Honor, I left out motion for discovery number 24 is pending. If that could be heard on.
What's that regards to, sir?
That is regarding. That's January 10th is the 2015 is the tragic killing of Mr. Donovan Thomas. And I just received videos from an incident allegedly occurring in 2015 that I was told previously that the surveillance did not exist. I still can't play the surveillance. That's at a movie theater, so I want the court to be aware that I have been asking for and put in writing. I want the videos. I think it's totally exculpatory from the McDonald's on Cleveland Avenue, as well as any street video traffic.
Is that okay, you said that's Williams 24?
Yeah, yes, discovery, motion for discovery 24. Then, Your Honor, there's also a motion to redact Mr. Williams' July 15, 2015 statement from the police, and you admitted it over my objection, so I'll stay on my objection. But, Your Honor, there are comments in there by Detective Racy and Detective Cunningham with Mr. Williams that the police were searched Mr. Williams' home that day. That search and the evidence that were found in that search has been suppressed previously, as well as in this court. So I just want the redaction, and I could show the state where those areas are. If they don't disagree with otherwise, we have to come to the court. And then the third motion that I just saw is motion limit number 40. I don't believe I said that to the court earlier, and if we could argue that if there's time, that's short also. And that deals with jail calls. If the state is going to introduce jail calls, they state are admissible of people who are not here or people who are here. And if the court over objection allows those statements for the people who are here who are alleged to be conspirators over objection, who they're speaking with are handing a lot of information.
I understand the rule of completeness, but there's a lot that has, I don't know which exact jail calls the state may want to introduce, but I'd like to give them a heads up beforehand. I'll be objecting to obtain third party, but it can't further, it doesn't further conspiracy. Anyway, I hope I make myself clear. That's the additional motion that I failed to bring up earlier. I don't know if the state wants to get together with me for giving what I believe should be excluded. Mr. Racy, Detective Racy, Agent Cunningham.
Okay, so that was today, and we are going to wrap it on up. Thank you so much for watching. Everyone who tuned in today, be sure to subscribe to my channel and like. We're trying to grow the channel. Again, we're trying to build and grow the channel. And this is April, TCG, and I am out. Peace.